shall come into force on the such date as the central government may by notification in the official gazette appoint.
It is not notified.
This hasn't happened. I will show further as to how this has not happened.
Restore also. Restore also. Take that.
These are the judgments of other high courts, my lord, where the question of notification has been considered. What learned senior counsel had produced on the last date is it is not decided that it was notified or not notified. Incorrect reference has been made. That is the submission I am making, my lord. If I invite your attention to the case of Gopal Krishnan versus Super Cassettes, the first case, if I may invite your attention to page number 6, paragraph number 18.
Yes.
The details of the factual case is not relevant, my lord. Analysis and reasons 18 and 19 is what I will read, my lord. The above submissions have been considered. It is to be noticed that the approval of scheme of amalgamation was under section 391 of the Act and not section 394. The corresponding provisions in the Companies Act 2013, section 230 is 230. However, at the relevant time when the appeal was filed, the provision relevant for the purpose of 391(7) of the Act, though in terms of Companies Act 2002, which is the act in question, my lord, section 397(1) stood omitted. The said amendment was to take effect only from the date notified by the central government. It has not been done. The purpose behind omitting the section 391(7) of the Act was to provide jurisdiction in respect of matters in relation to the mergers and amalgamations to the NCLT, which was constituted under the 2002 amendment. Till such time the NCLT was not constituted, there was no question of matters involving section 391 of the Act being transferred to it. The NCLT finally came into effect when the 2030 Act came into force on 1st June 2016. The fact remained that when the appeal was filed on 18 February 2013, section 391(7) of the Act continued in the statute book. The entire 2002 amendment omitting section 391(7) of the Act stood repealed finally on 14th May 2015 with the passing of Repealing and Amendment Act so and so. The position is, my lord, though it was passed and published, it was never notified. And when the 2013 Act and the consequent IBC were introduced, in the 2015 repeal of Act, the non-notified provisions were repealed, my lord. This 397, if I may show your lordships in the Amendment Act, it is a part of the same amendment. All of them are not notified.
Yes.
If I may invite your attention to the amendment section 39, which is on internal page 23. On top, second line, my lord, is page number. Amendment section in bold 39.
Where are you getting the numbers? Page 70?
Page 23, my lord. Second line on the left-hand side, my lord. SEC online web edition, page number X and Y. 23. Amendment to section 391 is section 39 of the amendment, my lord. If your lordship turns over the leaf, my lord, in page number 24 is the in subsection B, subsection 7 shall be omitted. 391(7) shall be omitted. That is the section this case is talking about, my lord. Though it was assented to by precedent, gazetted, but it was never notified as per section 1(2). The main reason behind this, my lord, is that the Company Law Tribunal was first conceived under 2002 Amendment Act, my lord. Because of the litigation in Supreme Court, it was never notified. There were supposed to be NCLAT equivalent and NCLT equivalent created under 2002 Act, my lord. Before the notification of IBC in 2016, these amendments in 2002 Companies Act to scrap Company Law Board and bring it in its place NCLT and NCLAT were never notified, my lord. That is the reason why these amendments were never notified. If your lordship wants further history of the provision, my lord, your lordship will find it in the other judgment that I passed. It is the Madras High Court judgment of full bench, 3 judges. Your lordship has, my lord. I will not trouble your lordship, my lord. I may indicate because they trace back the committees that have reported based on which the amendments were referred, my lord. And it also talks about the 4 acts which were amended around the time of 2002 to consolidatedly bring certain changes in the way in which companies are wound up. I'll just point out the paragraphs, my lord, and I'll read from paragraph 29, my lord, on page number 124 or page number 20, my lord. 124 is on top left corner, page 20 is on top. Paragraph number 29, my lord.
Yes.
29 onwards, all the changes brought about in 2002 and how they were published but not enforced is spoken about, my lord. Till about paragraph 42, this continues, my lord. If I may further invite your attention to para 62. It talks about the Amendment Act not being notified, my lord. 62 in page number 1.
Para 62 is missing.
May I pass?
60 jumps to 67.
Page number 133, my lord.
Hmm.
Non-notification is notified, my lord. After that, my lord, I will pass on 3 judgments of this honorable court where invoking the same powers, the matters have been transferred to this court, my lord.
Yeah.
All these have used 446(3) to transfer the case to this honorable court. Short orders. There is no doubt that the provision is
What do you
notified.
say, Mr. Singh?
Milord, just 2 points, Milord. There are 2 questions, Milord, which arise for consideration. The first, Milord, is there a power to transfer? Second, Milord,
In the light of the amendment.
yes, in light of the amendment, because Milord, 446(3) has been deleted, Milord, at least from the face of the act. The second issue is, Milord, if that power to transfer does exist, is it reasonable, Milord, in the facts and circumstances of the case to exercise that power? Milord, as far as the second issue is concerned, Milord, our position has always been, Milord, we really cannot have a substantive objection, Milord, as long as the trial is not held in a summary manner, because Milord, the nature of the dispute is about the quality of aviation engines. Milord, it literally is rocket science. And therefore, Milord, it is a matter which is very complex. It requires a lot of technical examination, Milord, and therefore the suit cannot be tried in a summary manner because of the subject matter of this dispute. The second aspect, Milord, is we have a number of preliminary objections, Milord, which is the subject matter of Order 7, Rule 11 and Order 7, Rule 10, applications that were filed before the civil court, Milord, which have been disposed of. Milord, the issues there are...
According to you, when you file an application for the rejection of plaint.
Yes.
What is according to you, the court has no jurisdiction?
Milord, the court does not have jurisdiction because, Milord, ultimately these are contractual disputes. In the contracts, the parties have agreed that the courts in England will have jurisdiction. That is one aspect, Milord, which has to be gone into. The second aspect is, Milord, there is a company with which the contract is entered into. But who have been arrayed as parties in the suit is not only the company which entered into the contract, but also shareholders of those companies. It is like saying, Milord, I am a shareholder of Reliance. Tomorrow, if Reliance commits a breach of contract, I as a shareholder can also be made a party to the suit. That is not the position of law. So these 2 questions, Milord, of course, will have to be examined. Those have been examined by the civil court, Milord. Our applications were rejected. Against that order, revision petitions are currently pending before this honorable court. So, Milord, those will have to be tried as a preliminary issue. So, Milord, these were the 2 concerns that we had in terms of Milord, it doesn't really matter where the issue is decided, but these are 2 aspects, Milord, that we wanted to place before your lordships kind consideration. The first point, Milord, in terms of whether this court has the power, my learned friend may in fact be right that the 2002 amendment may not have been notified. But the fact is, my lords, as your lordship had seen last time, if I could just trouble you, my lord, to
The apex court judgment.
the Supreme Court judgment, which says this specifically. My lord has seen this, I will not trouble my lord. I'll just read the specific portion, paragraph 27 of this judgment. In this connection, it may be mentioned that section 446(3) of the Companies Act was omitted by the Companies Second Amendment Act 2002. And evidently, the High Court has overlooked this amendment. As a result, in our opinion, the High Court has no power to transfer the execution petition. This is the law that has been laid down by the Supreme Court, which actually sets aside a High Court judgment on the basis that
Not looking into the fact that whether it is came into
Well,
effect
yes.
or not.
And therefore, my lords, my learned friend's argument, my lords, I of course understand it. But my learned friend is essentially saying that the Supreme Court judgment in this case was effectively per incurium because the Supreme Court did not notice that the 2002 Amendment Act was never notified. Now, my lord, as far as essentially what my learned friend is asking, my lord, this honorable court to do is to declare the judgment of the Supreme Court as per incurium. That, unfortunately, my lords, I just place the legal position and leave it to your lordships, my lord, cannot be done because the Supreme Court has said that no High Court can declare a judgment of the Honorable Supreme Court as per incurium. That can only be done by, my lords, a different bench of the Supreme Court itself. My lord, there are two judgments, my lords. We are just placing these, my lords, as far as the position of law is concerned, my lords, without taking any specific argument on it. My lord, these two judgments, which one? The two judgments, my lords, I'll just place those for your lordship's consideration. The first judgment, my lord, is Suganti Suresh Kumar at paragraph 9. Straight away go to paragraph 9, my lord, which is the proposition of law.
Let's understand para number from the facts, para number 3.
Para 3, my lord. The learned single judge of the High Court of Madras was not inclined to interfere with the sentence passed on the respondent, and therefore he dismissed both the revisions. Nonetheless, learned single judge has chosen this opportunity to send a message to the trial magistrate to keep in mind the objective of providing stringent punishment and the guidelines given by the Apex Court and so and so. After considering all that, at paragraph 9, it says it is impermissible for the High Court to overrule the decision of the Apex Court on the ground that the Supreme Court laid down the legal position without considering any other point. It is not only a matter of discipline for the High Courts in India, it is the mandate of the Constitution, as provided in Article 141, that the law declared by the Supreme Court shall be binding on all courts within the territory of India. It was pointed out by this court in Anil Kumar so-and-so that the High Court cannot question the correctness of the decision of the Supreme Court, even though the point sought before the High Court was not considered by the Supreme Court. The second judgment, my lord, is South Central Railways.
So let me just see this one. What is it?
Of course.
Para 11.
Well,
We have heard the learned counsel. Please read that.
when this court pronounced in Hari Singh.
No, para 11. We have heard the learned counsel at length.
Well, is the first judgment, my lord, or the second judgment?
So I am looking at the South Central Railway.
South Central, I'm so sorry. Paragraph 11, my lord.
Yes.
We have heard the learned counsel at length and have also considered the submissions made the judgments relied upon by the council, the earlier judgment delivered by this court and so and so. In our opinion, the High Court has committed a grave error by taking a different view than the one which had been taken by this court in South Central so and so, especially when the rules governing the promotion policy had not been amended after the aforesaid judgment was delivered by this court. It is pertinent to note that a review application has been filed in so and so, and the judgment delivered by this court in so and so had become final. Once in pursuance of a judgment delivered by this court, orders had been issued by the society to its employees who had been wrongly promoted. The High Court could not have held that the orders were not valid because there were certain other factors which had made the promotions given to the employees concerned valid. In our opinion, the High Court should not have considered any other factor, especially when this court had come to a final conclusion that the policy with regard to reservation in the matter of promotion to the employees was not legal and proper. We are of the view that it was not open to the High Court to hold that the judgment delivered by this court in so-and-so case was per incuriam. That seems to be the proposition of law. If the view taken by the High Court is accepted, in our opinion, there would be total chaos in this country, because in that case, there would be no finality to any order passed by this court. When a higher court has rendered a particular decision, the said decision must be followed by a subordinate or lower court unless it is distinguished or overruled or set aside.
Next judgment, which para?
Next paragraph.
2002 2 SEC.
Well, it's 2002 SEC is paragraph 9, my lord. It is impermissible for the High Court to overrule the decision of the Apex Court on the ground that the Supreme Court laid down the legal position without considering any other point. It is not only a matter of discipline for the High Courts in India, it is the mandate of the Constitution as provided in Article 141 that the law declared by the Supreme Court shall be binding on all courts within the territory of India. It was pointed out by this court and so that the High Court cannot question the correctness of the decision of the Supreme Court, even though the point sought before the High Court was not considered by the Supreme Court. We're just placing these judgments, but all these may be considered and an order may be passed.
It doesn't.
What do you say on that?
We don't, this court doesn't have to hold the Supreme Court judgment as per incuriam. It is,
Yes. Third is a
Deeply obliged.
Bill number 2,
Now, for the respondent number 2, madam.
intention of a for applicant.
oh, third response.
I appear for the applicant, my lord.
Lord, on
where is your
3-2.
application?
3/2/2025, my lord. Along with memo, my lord, I have produced few of the documents. May kindly be
New
positioned.
copy.
Hmm.
My
Is
lord.
it
Yes, sir.
3rd February 2025?
Yes, my lord. 3rd February 2025. Few documents have been produced by me.
Hmm.
First one, my lord, is the possession memo, which is issued by the,
Page number?
my lord, first page itself. That is the first page. First document, possession memo. My lord, issued by the OL, insofar as second respondent is concerned. Thereafterwards, my lord, a letter addressed to me by the OL, my lord, second document.
This is dated 11.
This is dated 11/11/2020. That is the date on which, my lord, the property is registered. That is the scheduled property is registered. Kindly see this letter for a minute. In the matter of so and so, your office letter dated so and so. With reference to the above subject, I have to inform you that the subject company was ordered to be wound up by an order dated 4/12/2012 of this honorable court of, by this honorable High Court of Karnataka, passed in company petition known so and so, and the official liquidator attached to this office, High Court. Honorable High Court became the liquidator of the said company by virtue of so and so. The official liquidator, in compliance with Honorable High Court of Karnataka order dated 6/2/2019, passed in so and so, has sold the immovable property situated at plot number so and so, measuring so and so, along with all the building and structures standing thereon in favor of so and so. As per the terms and conditions of the sale notice and said purchaser, the said purchaser is liable to pay the outstanding dues of property tax from the date of possession of aforesaid property, that is
So that is
16/7/2019, and property dues prior to this date will be paid by the undersigned jointly with so and so. This is the letter, my lord, which the OL issues to me, because one of the conditions for registration, my lord, is that all the taxes must be clear. With this undertaking, my lord, they go on with the same. There afterwards, my lord,
Which is document? Which is? Yeah.
But, we
memo
have
which
not
has been
got a
filed
copy,
by
my
me
lord.
on 3/2,
We have the
which your
copy of
people
it.
did not accept it when I tried to serve it. Anyways,
My lord, we have
I
not
don't
issued a
have
copy, my
copy.
lord.
take it.
My lord, we are all not.
My lord, kindly see the next document.
It's not served on them.
My lord, what has happened is, I don't want to say anything. I try to contact their office. My lord, no response. Tried to send my people there, no response. Lord, I contacted my senior friend. He said he will not take it.
You can't serve it on me.
I in fact collected a number of the concerned instructing counsel from him only.
Why you're not accepting the
Don't know.
memo?
Manoj, I believe we've not been reached out with respect to this at
No,
all.
no, I have
We are
tried out their
completely
number.
You
unaware
not take those, serve them.
I have served them.
I just got it. I just got it.
My lord,
Then we'll take it up on
respondent
some other
number
day.
2, we have issued copy.
What is your response to this?
To, my lord, you have heard me in, at
No,
length.
no, with regard to this letter.
I have served them also.
I say that they only have to pay, my lord. That is the objection we have taken. With respect to
No, no, you say that will be paid by the undersigned jointly with JM Financial, under which provision?
476, ma'am. That is the point that I
Same
had.
thing which you are relying on that day.
I have a judgment in addition, if you're lord.
Lord, one more thing, Lord, which I would like to bring to your lordship's notice is this. Lord, an affidavit is given by the second respondent.
Oh, that we have seen, that I.
Yes. No, an affidavit by the second respondent, my lord, that is the purchaser, my lord, saying that I am challenging this particular order of fixation of the property taxes before this honorable court. As and when the orders are passed on the writ side, he gives a writ number also. My lord, I will pay the amount. This is an undertaking which he gives to me.
What happened to those writs?
That writ petition, he withdraws.
My lord,
He withdraws.
my lord, for
My lord, this aspect is suppressed before your lordships also.
My lord, there is no suppression here. My lord, what has happened is,
Very same
all the-
counsel, my lord, files
all
an
the-
affidavit.
my lord, the property taxes that were due after date of, after meeting today, from the
Have
date
you
of-
received
my lord.
this memo filed by him?
No, my lord, we have not received any memo, nor has anyone from the
No, sir.
court of product, my
My
lord.
lord,
Serve it on me.
We have not got a copy at all. no,
this is the situation. He always remains on VC, my lord. We are not in a position to find out his office. No,
Sir,
this is the
kindly
situation.
email-
As and when, my
Sir,
lord,
put your email ID on the chat box, sir.
so
Email
that I can
consulting.
scan it and send it to them at least.
Yes. Give your email ID.
Previous date, I will go to the court.
No,
my
do
lord.
it now, do it now.
All that, my lord. I'll put it
Okay.
up. on chat box.
Next week, Lord, I'll.
Next week.
My lord,
Please.
can it be on Thursday, my lord?
Huh?
Can it be on 27th, my lord?
27. That's next Thursday.
Please,
On 20?
7th, my lord.
Yes.
Grateful.
Much.
That judgment which I passed on, my lord, is on point with respect to property taxes itself. I've served the.
Give me a copy.
Can I,
What is it?
can I have a copy?
Yes, sir. Take it.
For orders matter, cell number 3.
Much obliged, my lord.
Non-filing of
2
the-
weeks time,
Hmm?
my lord.
And for the respondent.
Backsided copies, my lord.
Or filed.
2 weeks,
Why 2 weeks, ma'am? 2013 matter.
yes, my lord, but judgment is in Kannada, my lord.
And
So,
claim
No, I
petition also
understand that,
dismissed.
for that, when it has come up last time, look at it.
Finally, we
No, finally.
can 1 week's time, my lord.
When is the order? On 13/2/20? It's a month already, more
Finally,
than a month.
Week's time, my lord. Will,
So please think twice before asking for time on a 2013 matter. This is matter finally next week. If the translated copy is not filed, the appeal will be dismissed.
26, 3. Cell number 4. Be promo.
Notes,
What are the translated copies to be filed in this?
I rely upon only the FIR which is in
For
Kannada.
that, why translation is required?
That's
You can
not,
argue.
please.
List this matter for hearing on, give the date
Yes, sir.
this week, or basing on the board. Yes, translated copies are not required.
3, 4.
Much.
Serial number 5. O Mahesh for appellant.
Yes, Mr. Mahesh.
I'm appearing for the respondent.
Mahesh sir. O Mahesh sir. He muted.
No representation for the appellant. List this matter for dismissal. In MFA number 6519. Yes.
Serial number 6. Suresh M.
Appellant,
Ashok N Patil.
as per number 4 will be dispensed. R3.
Take that. A memo is filed seeking dispensation of notice to R3. The same is, memo is taken on record and notice to R3 is dispensed with at the risk of appellant. Then we'll consider IA number 1 also.
Yes, you will ask me kindly condone the delay, my lord.
Huh?
You will ask me kindly condone the delay.
IA number 1 of 17 is filed to condone the delay of 81 days in filing the appeal for the reasons stated in the accompanying affidavit. The delay of 81 days is condoned. List this matter for,
Minutes, may I seek minutes on indulgence? The minutes, it is, the appeal is filed seeking enhancement for damages to the vehicle, my lords. Now, what they have expended, my lords, is 97,900
it can be disposed of.
disposed of minutes within the.
What is the amount that was claimed?
Minutes, they have claimed, my lords, 1,50,000. My lord, the tax invoice which is produced, my lords,
So no, 1,50,000. How much was awarded?
but now awarded is, my lord, 67,436. What they have expended, my lords, is 97,990. But the difference would come, my lords, to rupees 30,560, my lords. They would be additionally entitled, my lords. This is how, my lords, because, my lord, they have the enhancement would be, my lords.
Please come to that particular finding with regard to the money spent by them.
Please.
The order,
My lords, at paragraph number 19, you should may kindly see
paragraph number.
19 of the judgment. This is what, my lords, his insurer, my lords, has paid it to him. The difference is, my lords, this 30,560, my lords.
Where is that?
But that finding, my lords, because this document,
No,
What?
about, there should be a finding about what is the amount spent by them.
my lords, it is not come in the, my lords, because he has given me, my lords, a copy now, my lords, where it shows
But
that.
if their pleadings, it would be there.
Please, he simply says, my lords, it is 1,50,000. It is not that, my lords, he has expended that amount. My lords, I will.
And what is the document to show about this 97,990?
My lords, he has produced, my lords. In fact, he has given.
That is exhibit?
My lords, it is not, unfortunately, not marked, my lords.
Exhibit P7 letter.
Then what basis the court will increase it now?
My lords, let him file it by way of a memo so that, my lords, can take it.
Who
on
that?
record.
Yes.
Land counsel appearing for the appellant submits that they have spent an amount of rupees 97,990 for the repair of the vehicle. And the said document, they could, they was not filed before the trial court. And he seeks time to place the same on record. This is matter next week.
Already,
with your
exhibit P7
lordship-
estimation copy already filed.
Yes.
Your lordship, leave, my lord, serial number 5, I just missed it, my lord. I pray for a week's time, my lord.
You 5?
I have to supply copies and also amend the. LR application has been allowed. I have to pay process, my lord.
Finally, for the petition shall do the needful within a week. No further time will be granted.
Please.
Yes, next.
Serial number 7. A Venkatesh, appellant.
Well, appellant, my lord. My lord, R1 is dead.
Hmm.
I filed a memo to that R2 represents R1, mother and son. Mother is dead. Her estate is represented by second respondent's son. Filed a memo, that memo is not put up, my lord.
There is a
25-2, I filed the memo.
a memo is filed stating that R1 is the wife of late Ramaswamy R2 is a
Son
son
of
of late Ramaswamy. As R1 is no more, already the legal representative, that is R2 is on record. Hence, the
Marimuthu.
second respondent may be treated as a legal representative of the deceased R1. Accordingly, memo is taken on record and the petition shall carry out the necessary amendment to the cost title. Yes, next.
Records may be called for.
Hmm?
Records may be called for. It has not come.
Ministry is directed to call for the TCR.
Cell number 8,
Shall I amend the petition?
cell number 8, Vijeta Arnaik,
As per the order passed by the court, the
acceptance. R7, Qasim Sab,
they have taken out paper publication and filed a memo for acceptance of the paper publication accordingly. The same is accepted. And the notice to R7 is held sufficient. Yes, this is directed to call for the TCR. This is matter for hearing.
cell number 9, Satisha T. memo.
My lord, there is already a direction by the other court that this matter be put up along with MFA 2884/2023. And hence I request this honorable court to kindly order for putting up this matter along with 2884 in accordance with the orders passed by this honorable court itself.
I am at the time of filing without my knowledge filing two appeals. Another matter is both are same advocate. Kindly withdraw this appeal.
What happens if he withdraws this appeal?
My lord, what has happened is this matter is earlier in time. The later appeal is 2884/2023. And there are orders in this writ petition, which, in this appeal, which is binding on my learned for on the parties.
This matter.
That is why this
along
has to
with
be
the so and so before the other bench.
2884/2023.
The number, yes, next.
I will give the number.
Hearing on interlocutory application, cell
Yes, I number 1 of 18 is filed to condone the delay of 3 days in filing. Considering the reasons stated, the delay is condoned. Registry is directed to call for the records.
Great.
Matter for hearing. Yes, ma'am.
cell number 11, NK Siddeshwara,
I appear for appellant.
Who
This is a-
appears for the respondent?
Owner's appeal, my lord. Liability is fixed against the owner solely on the ground that, my lord, the
No, which insurance? PB Raju for.
PB Raju, yes, ma'am. Pay and recovery has to be ordered
That's
because.
what the council.
PB Badrinath.
Inform him, we'll take it up in the afternoon.
Please,
Pass over.
please.
Yes, next.
Cell number 12,
I number 1 of 22 is filed to condone the delay of 61 days.
May be allowed on cost, my lords.
Huh?
Delay is the 61 days delay may be allowed on cost, my lords.
I number, cost, what cost? I number 1 of
First
22
time
is
hearing
filed to
this,
condone the
order
delay of
44.
61 days in filing.
Sir, you're hearing that.
Considering the reasons stated, the delay is condoned. What is the?
Submission, I am
matter?
ready for disposal. Only quantum only, please.
You are questioning the quantum.
Please, my lords, any date may be fixed, my lords. Any date may be fixed, my lords.
This is matter. Give a date basing on the dates. Yes.
Grateful, my lords.
Next,
cell number 13, admission matter, cell number 13, Chantraj K.
I am representing CH.
what has happened? This came up on the other day,
Uh,
come up on the other day.
Yes, ma'am.
Why it is adjourned?
Adjourn, last occasion he has not appeared and another occasion, what he has appeared.
Hmm.
I took a time, my lord. I
Huh?
have not filed wakalat.
Ah,
Can adjourn.
on your request. it is
Ah, yes,
adjourned,
madam.
Yes. What is the matter about?
My lord, is the synopsis. Case of injury.
Take that.
It's a case of injury, my lord.
Hmm.
Date of accident 21/1/2011. He was working in the team leader in Cab Gemini. He is continuing the same job. Loss of future earnings not awarded. He has sustained, my lord, fractures, my lord, para 12 of the judgment, my lord.
Fracture of right tibia, fracture of right.
Fibula.
Stated over right leg,
Medial malleus.
15, pain and suffering, 40,000. Laid up period.
Laid up at 3 months, my lord, 43,544 would be the salary. The same has been considered, 3 months awarded me.
Future medical expenses,
35,000.
35,000.
My lordship
So
has
what
to,
is not awarded is,
my lordship has to interfere with pain and suffering and loss of immunities because there is no loss of future earnings. Please. 4 days inpatient.
loss of amenities.
20,000 has been granted.
Hmm.
Lordship may grant another 20,000.
Hmm.
And pain and suffering, 40,000 has been awarded, my lord. That also, my lord, there is 3 fractures, my lord. Another 20,000, my lordship may increase, my lord. Rest of the aids, my lord, just and reasonably as granted.
60,000, that means 20,
40,
40,000 and another 10,000,
Please.
50,000. So it would be 2 lakh.
2,90,632.
632.
Please.
Please come. Agreed with orders passed in MBC number 1797 of 2012, dated 20th August 2013. The claimant is before this court seeking enhancement of the compensation. The claim petition is filed seeking compensation of an amount of rupees 10 lakhs for the injury sustained by the claimant in the accident. It is the case that the claimant had sustained fracture of right tibia, fracture of right medial malleus, lacerated wound over the right leg. And as per the evidence of the doctor, the disability is 10% to the whole body. The court had awarded the compensation as per the table given below. Land counsel appearing for the appellant claimant submits that when he had sustained 3 fractures under the head of pain and suffering, and when there is disability of 10%, the amount that is granted by the court towards loss of amenities on the lower side. Further, the court had not granted any amount towards the future loss of earning concerning the disability. Next para. Land counsel appearing for the insurance company submits that court has rightly considered and granted the compensation. It is submitted that though he has sustained 10% disability, there is no evidence to show that it had an impact on his future earning. In that case, he is not entitled for any amount towards loss of future earning. It is submitted that the compensation that is granted is a just and reasonable compensation. Next para, having other counsels on either side, there is the material on record. As per the evidence of the doctor, he had sustained 10% disability to the whole body. He is working as a team leader in Capgemini. What is the impact on his future earning because of this disability is not forthcoming. In that view of the matter, this court is of the view that the court has rightly not granted the amount for loss of future earning considering the said disability. Coming to the loss of earning, loss of amenities, considering the injury and the disability, this court is inclined to grant 40,000. Then coming to the pain and suffering and considering the fractures, this court is inclined to grant an amount of rupees 60,000. On the other counts, court had rightly granted the compensation and there are no grounds to interfere. In the light of the law laid down in so and so, the claimant is entitled for an amount of rupees 10,000 towards legal expenses altogether. The claimant is entitled for an amount of rupees 2,90,632. So now, take this calculation. Accordingly, the appeal is partly allowed. Yes, next.
So number 14. TV Nanjagowda for appellant. DV Arun Kumar.
Who appears for the respondent?
TV Arun Kumar. EN Arun Kumar.
Yet met, post for final hearing. No
And
representation for the respondent. Yes.
number 15. Yeah, Srinath. HS Lingraj for respondent.
Number 1, my lord.
No representation for the appellant. Admit, post for final hearing.
Cell number
Call for the TCR.
yes. Cell number 16.
Respondent claimant, my lord.
My lord, I appear for the appellant and delay may be condoned in the connected matter and
IA number 16.1, IA number 1 of 18 is filed to condone the delay of 540 days. No objection, the objections are filed with the respondents. Considering the
formal
reasons-
objection.
Considering the reasons stated, the delay of 540 days is condoned on the condition that the claimant will not be
No, my lord, that question doesn't arise.
Owner appeal, my
Owner's appeal, owner's appeal.
The connected appeal filed by the owner, my lord.
owner of the
Owner.
is condoned. Yes,
Finally.
next.
Number
Already TCR is called for. This is a matter for final hearing.
Yes.
Yes.
Cell number 17. 17 adjourned, 18 adjourned, cell number 19. Yes, Nirmala. Ravi Shankar, yes.
Another case.
Let this 2020 matters come little later. Admit.
Yes.
Yes.
Cell number
Post for
20.
final hearing.
Date maybe.
Yes.
Cell number 20.
Madam, date kotra.
Same, they'll give the date. Basing on the,
21st April.
yes, 20 also, 20,
Cell number 20.
20.
admit.
Even I will not. Yes,
Call for TCR.
20.
TCR not required, my lord.
Only an
For
answer.
the TCR, because 17, 13, 14 matters.
Oh,
are
all
pending, that's
all
why.
right. Correct. Your
But go with this 21 now.
Very well. Yes, sir. We issued the amount also.
TCR.
Finally.
Yes,
Cell
next.
number 21.
For
Call for admit. TCR is already there.
Ready there, final hearing. Cell number 22 adjourned.
Yes.
List number 2. For order, cell number 1. Virupakshaya PH for petitioner.
Yes. Yes,
My
who
lord.
appears for the petitioner?
I'm on respondent side.
No representation for the petitioner. This is matter for dismissal tomorrow. Next,
Cell number 2.
My lord,
there are so many matters.
Connected.
Dismissal tomorrow.
my lord. My senior is not well, so I needed 1 week time.
Cell number 2.
Serial number 1.
1.
Cause list number 2, serial number 1.
Virupakshaya.
If any of counsel is not there, petitioner will post it for dismissal. No, she's for the respondent.
Respondent, sir.
Respondent.
Yes, next.
Cell number 2. Petitioner and Shivaramu.
Notice to respondent
Yes, ma'am.
received as refused, amounts to deemed service of notice. No representation for the petitioner. This is matter for dismissal tomorrow.
Cell number 3. Puneet. C for petitioner.
No representation for dismissal. 4, after service of notice.
Cell number 5.
Yes.
Appellant. My lord, this is a case wherein we have to set aside a temporary injunction given by the principal JMFC Ramanagara. The brief facts is this.
On the maintainability.
On the maintainability. Yes, my lord. So, my lord, I have to procure.
When an injunction is granted, if you are agreed by it, you have to file an appeal to the next court.
Yes.
But
That is-
not a miscellaneous MSA before this court.
My lord, that has also been done wherein the IA has been upheld what has been given by we have filed a thing in the first additional court as well. And they have again upheld the temporary injunction given. So agreed by that, we have approached this honorable court, my lord.
You that. Then again, is that our MSA lies?
So yes, my lord, my submission is this, my lord. I have to procure some more documents because this is a new.
Procure documents. First of all, now in the against an order of injunction, you approach the appellate court. Appellate court had confirmed the orders. Against that, how a MSA will lie? Against that, you have to file the writ petition under 227, but not an MSA. That's on the maintainability. Yes,
It's serial number 5 minutes.
yes.
MSA is not maintainable.
The appeal is filed. Exists an order where the trial court has confirmed the injunction that is granted in favor of the plaintiff. The registry has raised the issue on the maintainability, and that's why it's placed before this court. The MSA is not maintainable, and the petitioner is at liberty to file an appropriate petition within a period of 1 week from today.
Much obliged.
Yes. Yes, next.
Seal number 6. Devraj,
Filing a memo of conversion and file a petition.
Take that.
Not maintainable.
Because all these cannot be done at the time of mentioning.
Yes.
Court has to look at it.
I understand. I challenge the order of the first appellate court, setting aside the temporary injunction. So,
The present appeal is filed against the order of the appellate court where the appeal filed by the defendant is dismissed.
No, it
Against
is
that,
allowed. Appeal filed by the defendant is allowed.
appeal filed by the defendant is allowed. Against that, the plaintiff has filed the present MSA. The office has taken the objection with regard to the maintainability of the appeal. The present memo is filed seeking conversion of this MSA into writ petition on 227. Accordingly, the memo is taken on file and on record, and the petition is permitted to convert this MSA accordingly disposed of.
Great.
seal number 7. Withdrawal.
Filed a memo for withdrawal, ma'am. I've sought for issuance of the succession certificate. I'll approach the jurisdictional court is a civil court, my lord. Henceforth, I pray for withdrawal of the matter, my lord.
Both the matters,
Both the matters, my lord.
7 and 8. A memo is filed seeking to withdraw these two petitions as a office has raised the issue of maintainability. Land Council filed a memo stating that they may be permitted to withdraw these two petitions and may be permitted to approach the jurisdictional court and sought for return of the original certified copies of the documents. Accordingly, the memos are taken on record. The petition is permitted to withdraw this petition and file an appropriate petition before the appropriate court. Registry shall return the original documents.
Much obliged.
Yes, next. Yes.
Seal number hearing on interlocutory application. Seal number 9.
I am for appeal.
Patiently.
But I have filed the objections, my lord, with regard to condemnation of delay.
You want to?
I have filed
Uh,
this one, objections, my lord. However, my lord, this is covered by the judgment of this. For this reason, my lord, we have not party before the trial court. my lord.
Same order as
Same
the
order.
earlier order. This court has already passed several orders that KA has taken. Those orders with regard to this remand. What are other conditions in that? IA number 1 of 18 is filed to condone the delay of 1349 days in filing the appeal. The objections are filed by
Respondent
R3.
R3.
R3, which is a beneficiary and which is not a party to the land acquisition proceedings or.
My lordship, my submission, my lordship. Regarding the, whatever the objection they filed, that is irrelevant. I know, already earlier, there is an order.
I am condoning the delay. What did you write? Now, land acquisition proceedings or before this court. Now, you have filed the implead petition or they have filed?
They have
I have filed.
And now they have filed the implead petition before this court.
And my lord, it is allowed and we are already
You're
on
already
record,
parties in this.
already on record in this case, in the appeal.
And implead petition is ordered. And the third respondent is already on record. And on behalf of the third respondent, they have already filed their objections. This court has perused the objections, considering the fact that this is a land acquisition proceedings and proceedings. And already the similar matters, appeals or remanded by the court. This court deems it appropriate to condone the delay of 1349 days in filing the appeal. However, they'll not be entitled for interest for the said period. The said period. Accordingly, IA number 1 of 18 is allowed. Then coming to the main matter, in the light of the order passed in the connected matters, take that in so and so and so and so. Give that. The main order should be like this. These proceedings are arising out of the land acquisition proceedings initiated.
And what about that?
The notification, then preliminary notification dated 38/2007, and the subsequent award that is passed. The claimants have approached the claimants are aggrieved by the amount of compensation that is fixed by the reference court. In respect of the very same land acquisition proceedings, when the other claimants have approached this court, that is in MSA number 43 of 2023 and MSA number 42 of 2023 dated 18th 23 by order dated 18th December 2024, this court has remanded the matter to the trial court for fresh consideration. In that consideration, and in the light of the same, this court also deems it appropriate to allow this appeal and remand the matter to the trial court, to the reference court for fresh consideration. Accordingly, the following, the MSA miscellaneous second appeal is allowed. The order of dated so and so is set aside, and the matter is remanded back to the reference court for fresh disposal.
One kind submission regarding this, can I submit my last? I need to submit on small submission regarding this. I'll ask you what, already it is, in the earlier cases, it was ordered to revoke the lower court order, to set aside the. What I am submitting here is what we are facing as being a claimant. One thing I want to clear that as a beneficiary, they can't sue against the donor. Actually, in between donor and donee, here
No, their implead application is allowed.
Yes.
The second respondent, your third respondent here.
Yes, third respondent.
Third respondent herein shall be made as a party in the reference court. Next. The liberty is reserved to both the parties to adduce evidence in further, if they are so advised, either oral, documentary, or both. All the parties shall be present before the reference court on which date?
April 3rd week of.
8th of April. 8th of April, 2025. Then what about this return of the court fee paid by the claimants shall be refunded to the claimants, the proper identification. And the reference court shall pass appropriate orders within 6 months from that date, from the so and so date.
And
Yes.
third week, madam, 8th, instead of 8th, third week, maybe we can come.
Third week, 15th.
Please.
Cell number 10, MC Basavaraju, case Vimaya.
Delay of 737 days.
Huh?
There is a delay of 737 days.
This is nothing to do with the other acquisitions.
No, your lordship, already the trial court made an order that whatever the compensation amount given, that can be deducted. Please pass.
Take that. What is this order?
Trial court order.
Trial court order will be there in the record. The IA number 1027 is filed to condone the delay of 757 days in filing the appeal, filing the present appeal. The respondent number 2 has filed the objections for the same, considering the reasons stated in support of the unknown delay petition and the fact that the matter arising out of the land acquisition proceedings, the delay of 757 days is condoned in filing the appeal. Yes. This is matter. Reservation. Yes. No, in the other matters also, the delay has to be condoned on the condition that they are not entitled for the interest.
Yes.
Earlier matter also, in this also, they are not entitled on the condition that the claimants are not entitled for a period of 757 days. In the other matter also, same, 1359 days or 49 days also.
Cell number 11,
Please, Your Lordship.
Manoj Kumar. Manoj Kumar.
Lords, the delay is 1,460 days. My lord,
Notice to the respondents.
my lord, one submission. These appeals arising out of another set of appeals were filed, my lord, having the same subject matter for a notification. It was remanded back.
No beneficiary in this.
No beneficiary. Beneficiary was not made party in this also. ma'am.
You have to make them party.
Yes, ma'am. I have impleaded them.
Where is that? IA2.
IA number 2, my lords.
Who appears for them?
Lord, Standing Counsel KS Bhimaya, if I'm not wrong.
And one more counsel is also there.
Yes, my lord.
Prashant
State.
Ratri. He was somewhere here. Inform him, pass
Please,
over.
please, my lord.
Yes. Yes, next.
Admission, cell number 12.
For petitioner, my lords.
Sir,
The petitioner herein entered into a marital relationship on
Taking
15/3/20
transfer from where to where?
from Bangalore to Mandya, my lords.
Bangalore to
Mandya. That is,
Mandya. What is the distance?
my lords, 100 kilometers, my lords.
Huh?
100 kilometers, my lords. Approximately a 2.5
Which year is MC?
my lords, MC is of 23, my lords.
23.
23, my lords. And meanwhile, the respondent herein filed a petition for dissolution of marriage on 20.
What is the stage of this MC?
My lords, my lords, sorry, my lords.
The respondent, my lord, filing my statement of objections.
Have you served on her?
No, my lords.
No,
No, my lords.
we could not supply them.
Then counsel the respondent submits that. File in the counter.
Please.
Submits that he'll file the statement of objections. The same shall be served on the other side. This is matter on Thursday. Not
Well,
next Thursday. Yes.
Interim
Very well.
prayer earlier granted may kindly be extended, my lords.
Interim order earlier granted is extended till then.
cell number 13. A. Madhusudan Rao.
For the petitioner,
Petitioner.
seeking for transfer of the petition filed for restitution of conjugal rights before the court in Bangalore to Chikmagalur, my lords. The marriage between the petitioner and respondent was solemnized.
Distances?
My lords,
Distance.
distance is about 250 kilometers, my lords, 270 close.
Children in the wedlock?
No children, my lords, but she's a diabetic and she's not employed.
Who resides in Chikmagalur?
She resides in Chikmagalur.
With
She's
whom?
with her parents.
Yeah, for respondent. So no objection to transfer the case from Bangalore to Chikmagalur. But directly trial court to speed it is for allowed.
Which year is the MC?
20,
File the MC for conjugal rights.
Year.
24. my lords.
24.
Marriage is also
How can
24.
it be expeditious? We'll say that the wife shall cooperate with the,
There's
and she
also
shall
a
not
pet-
seek adjournment.
There's also a petition.
The petition is filed. Seeking transfer of MC number 554 of 2024 filed by the husband. Which is pending before the third additional senior judge Bangalore to the court of principal judge family court Chikmagalur. It is a case that the distance between both the places is about 250 kilometers. And the wife, and it's difficult for her to travel. Next parallel and counsel appearing for the respondent husband submits that. They have no objection to transfer this petition from Bangalore to Chikmagalur. However, there shall be a direction to the trial court to expeditiously dispose of the matter. Next para having heard the counsels on either side. There is a material non record. Considering that as a husband has no objection to transfer the same, this court is inclined to allow this petition. However, the request made by the husband cannot be considered as this is MC of 2024. In that view of the matter, this court is passing the following order. So and so is withdrawn from so and so and transferred to so and so. Next part, the wife shall cooperate with the case and shall not seek unnecessary adjournment.
Then number 14, Bhushani Kumar for petitioner.
Here for the petition. The respondent has been served in this matter.
Sir,
Yes, ma'am.
where is the memo?
It is shown even in the cast list also. Praveen respondent served
How-
and I have
Okay.
taken.
Seeking transfer from where to where?
From Honnavara to Bangalore, my lord. They were living together at Bangalore at Rajrajeshwari,
Honnavara to Bangalore.
which is about 500 kilometers. The daughter, who is about 11 years, is
Is with the mother.
with the mother and studying here in Bangalore
Husband filed at that place.
at Honnavara.
Served?
Yes, ma'am. I have the extract also I have taken, but it is in the cause list itself, it is shown as Praveen respondent served.
Hmm?
Tracking also shows that he has been served.
Confirmed, I think. Then counsel for the present petition is filed, seeking transfer of MC number 62 of 2024, pending on the file of the senior civil judge and JMSC Honavara to the family court at Bangalore. It is submitted that the respondent herein, the marriage had taken place between the parties on 29/11/2012 at Havyaka Kalyana Mandapa, Karki. And in the wedlock, they're blessed with a baby girl on 28/10/2013, who is 11 years old now. In view of the differences between the parties, the wife is residing with the parents at Bangalore and the girl is studying at Bangalore. On 21/12/2024, the husband had filed the MC, it's for restitution or divorce?
For divorce.
Seeking divorce on the file of the senior civil judge and JMFC Honavara. It is submitted that the wife is residing at Bangalore and the distance between both the places is how much?
500 kilometers.
500 kilometers, and it's difficult for the wife to travel all the way. The notice is served on, as per the cause list, it shows that the notice is served on the respondents, no wakalat is filed. Considering the fact that the distance between both the places is 500 kilometers and the wife had to take care of the child, this court deems it appropriate to allow this petition accordingly. So and so is withdrawn and transferred to so and so, and the wife shall cooperate with the case. Yes.
Then number 15, Manjunath B.
Because the petition is,
Coming up for the first time?
my lord?
Coming up for the first
Yes,
time?
yes, my lord.
What is the distance?
Distance is 280 kilometers from Chikmagalur to Bangalore,
Which year is this?
2024, my lord. Marriage was solemnized on 2024 itself. March 2024, only 2 months she has lived with,
By the wife.
yes, my lord. Well, I'm for the husband.
Why you are seeking transfer?
My lords, I have old age divorced mother, sorry, I old aged mother. She is widow and I have to look after her, my lords. And moreover, I
The
have
distance between the both the places?
280 kilometers.
And she has no one that she can travel and you cannot travel.
No, my lord, she is residing there with her parents,
Where?
with Chikmagalur. She is residing in Chikmagalur and I am residing at Bangalore. We both,
She also has to travel.
my lords, but
You're seeking transfer from Chikmagalur to Bangalore.
yes, my lords.
No, if it is transferred, she also has to travel.
Yes, my lords.
She also will have her own
The
problems.
main ground for this petition is that while conducting panchayat before the elderly family members with regard to this matrimonial issue, there was open threat by their cousins.
And in that case, have you given any complaint to the police?
No, my lords, but they have threatened that if he comes to Chikmagalur,
That's what, if that is the case, bearing on your oral assertions, the court cannot consider.
yes, my lord,
If you say that there is threat, you should have given a complaint to the police. You have not done.
not done.
Please come.
My lords, Chikmagalur case, they are posting day to day, on day-to-day basis, my lords.
That is
I'm
a
not able
different
to attend,
aspect. Now, in a transfer case, we will not,
I'm not able to attend, my lords. I also have my dependent mother. She is aged about 70 years, my lords. She is a widow also.
then ask them to give some dates. But that can't be.
But they are not adjourning the matter from to the day, yesterday they have posted for my matter for tomorrow, my lords. Like
Because
that.
you said that CP is pending.
Yes, my lords. I have also filed a memo.
Dismissing the CP, now you will
Lords.
ask for the dates and go before the court.
Lords, kindly, a notice at least may be issued to them. my lords.
No. Why notice? The present petition is filed, seeking transfer of. What is this civil, criminal miscellaneous?
Criminal miscellaneous is the maintenance case which he had filed. I have filed for restoration of conjugal rights.
No, present petition is filed for what?
For transfer of criminal miscellaneous case to,
For that the CP will lie.
plus that is for maintenance for 125 CRPC she has filed.
How can the transfer petition will, it has to, transfer criminal petition will go to that other court at 125 CRP. How this is numbered, ask them. Pass over. Yes,
Number 16. Megalamane Prabhu.
yes.
Petition case. This is the transfer petition from Assam.
Filed by whom? Filed by whom?
Wife, sir, wife.
From where to where?
Assume Assam district to Shivamogga district, sir.
Distance?
150 kilometers.
Which year is the MC?
What's pardon?
Which year is the MC?
Which year? 2014, sir.
Huh?
2014.
MC is of the year what?
MC filed by husband, sir, for divorce. 2014, sir. 24, sir.
2014 and 24, 10 long years.
2024 files. Alex raised,
The
sir.
present petition is for seeking transfer of MC number
One more, small baby, this one.
137 of 2014
List, stay.
from the Senior Civil Judge JMFC, Chennai Patna, Hassan District, to the Family Court Bhadravati, Shimoga District. It is submitted that the distance between both the places,
Some
Distance.
distance 150 kilometers.
Mike use my distance.
150 kilometers.
150 kilometers. And
Small
he has
baby
to
also
take
there.
care of a girl, a small baby. Considering the reasons stated, there shall be stay of all further proceedings in so and so, so and so. The petition, till the next date of hearing, the petitioner shall take out hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to that effect by 7th of April, or else the state standard granted by this court shall stand vacated without further reference to the court.
Then number
Next.
17, Srinivas V. For petitioner.
We are seeking transfer of case, madam.
First of all, wife or husband?
Wife, ma'am.
Wife, from where to where?
From Puttur to Madikeri, ma'am.
Huh?
Puttur to Madikeri.
Puttur to Madikeri, distance.
90 kilometers, my lord.
Which year is the MC?
25, my lord, 2000.
25. The present petition is filed with the wife seeking transfer of MC pending MC number 5 of 2025 pending on the file of the principal senior judge and ACJM at Puttur and transfer the same to the family court at Madikeri. It is submitted that the distance is 90 kilometers. 90 and children,
Children 5 years old by.
and she has to take care of a child aged 5 years, and it's difficult for her to travel considering the submission of the land council. Same stay, hand summons, and shall file a memo by, or else the stay granted by this court stands vacated. That was for
18,
further reference.
Srinivas L.
Petitioner.
Yes.
The petitioner filed a transfer petition before this honorable court. Marriage was solemn.
Who is the petitioner?
Petitioner is wife.
Uh,
Respondent, he is the husband of filed the MC
From where
petition.
to where?
Maduru to Bangalore.
Madhu to Bangalore.
Is a distance more than 120 kilometers, sir.
Children, which year is MC?
2024. As soon as possible, the petitioner filed a MC petition before the third additional
Any
Bangalore.
children in the wedlock?
2020. Vara.
Children.
No issues.
The present petition is filed seeking transfer of MC number
105 or 2020.
MC number 105 of 2024 which is filed on the file of the Senior Civil Judge JMC Court at Madhu to Third Additional Family Court at Bangalore. It is submitted, the distance is about 90 kilometers. And she has to take care of the child, no child. It is submitted that the distance is so and so, and she has already filed MC before the court at Bangalore. As such, considering the same, the petition that's pending at Madhu needs to be transferred to Bangalore. Considering the distance and the reasons stated, there shall be stay of all further proceedings. Same. And summons also you have to take, file a memo to that effect, or else stay will be vacated. Yes, next.
Cell number 19. Sriram.
The petitioner wife, my lord.
Hmm.
Husband is filed the RCR before the Madhur JMFC court. The distance is 81 kilometers, my lord. The petitioner wife is staying in Bangalore with her 2 children.
Which year?
2024 MC.
The present petition is filed seeking transfer of MC number
33 of 24.
MC number 33 of 2024 filed by the respondent herein seeking restitution of conjugal rights from Madhu to
Bangalore.
Bangalore. It is submitted that the distance is 90 kilometers and the why it's difficult for her to travel. Considering the submission, same stay of all further proceedings and memo, hand summons, and you shall file a memo. What is the date in the early? 7/4, or else the stay granted by this court stands vacated.
One more submission, man. Hand delivery may be permitted because there is a trial date. It's tomorrow, my lord.
Yes.
Grateful, man.
Next.
Cell number 20.
Lord, I appear for the petitioner, my lord. Wife's petition seeking transfer of matrimonial proceedings from
Yes.
Bangalore family court to family court at Mysore. The distance is around 150 kilometers, my lord, and she has 2 minor children out of which.
Notice is not 20, and for the respondent, notice is not ordered. I want that petition copy. Soon I will, next date I will argue, my lordship. Serial number 20. And for the respondent, I will file the wakalat.
Pallava.
I appear for the petitioner, my lord.
You are here.
No, I don't have the petition copy, my lord. This is the first time I am coming.
Only ground we have urged is that,
But
my
ordering the
lord,
notice, I am coming, that's why.
she has 2 minor children and one is aged 1 year. my lord.
Then council so and so submits that. He has filed wakalat and he'll come up with his objections. This is matter next week thereafter. Yes, next.
The lordship may fix a date, my lord.
Petition copy.
I'll serve, my lord. I'll serve, my lord. I'll serve the copy to the respondent, my lord.
Yes.
Your lordship may fix a date, my lord.
24, sir.
Okay.
April 3rd.
Grateful.
And,
21.
and my another one submission is there. 20th is the mediation, my lordship. I am waiting here the mediation. She is not come, but in court it is submitted that she will come for the mediation. That's why I request this honorable court to direct her to come for mediation. One opportunity I required, my lordship, because both are in good term, both are in good only. Only in small issues it's issues raised. That's it.
Yes.
My lord, in fact, she has a minor child, my lord, who has just turned 1 year. February 2025, she has turned 1 year. It is very difficult to
No,
leave
he
the baby.
says that he's ready for mediation. What is your client saying?
Now, I have to seek instructions, my lord. Anyways, on the next date of hearing, I'll submit. If possible, my lord, I'll keep her present.
Yes. Yes, next matter.
Cell number 21.
Petition by wife. Husband filed the petition before court, Bangalore. Resident address of
Filed by the husband.
Petition by the husband. He is also shown that he is the permanent resident of Mandya district. The petitioner herein is residing at Mandya, and she has to take care of 6-year-old daughter. That reason.
Your husband is taking care of the 6-year-old daughter.
No, wife is taking. Petitioner.
Petition is the wife.
Yes. She has to take care of 6-year-old daughter, and respondent is in MC petition. He has shown his permanent address is Mandya.
Now tell the court first of all from where to where you are seeking transfer.
Bangalore to Mandya.
And the wife is staying at Manya.
Yes, madam.
See, in the earlier order, the present petition is filed seeking transfer of MC number. What is the number?
2493 of 24.
2493 of 2024. Pending on the file of the 5th Additional Principal Judge Family Court at Bangalore and transfer the same to the Principal Senior Judge and the CJM at Mandya. It stated that the distance is 90 kilometers and she has to take care of the child. Considering the submission, there shall be stay of all further proceedings. Same hand summons. or else a stay granted. What is the date? By 7th, a memo shall be filed, or else a stay granted by this court stands vacated. Next.
Cell number 22. 22. That-
Yes, Passover. Next 23.
Kindly, it may be taken 2:30.
Passover will be called as per the other Passover matters. Yes.
Cell number 23.
We are for appellant in this case. I withdraw the appeal, my lordship.
Hmm?
I withdraw the appeal.
You want to withdraw the appeal?
Yes, my lord.
Where is the memo?
I,
Write the memo and give.
Okay.
Then they will call it. Once he gives the memo, then you call this. Yes.
Cell number. List number 3. Cell number 1. Number 3, serial number 1. O Mahesh for appellant. S Raju.
My lord, I am appear for appellant, my lord, in
Where
MFA
is-
number
where is Mr.
148.17.
O Mahesh, sir.
He will be online all the time, but he won't respond.
O Mahesh, sir. Sir, please unmute.
Will pass over.
1 week time, maybe.
2011 appeal, no time,
Our matter, my lord, 2017.
maybe. Yes,
Pass.
pass over. Next matter also pass over.
Cell number 2 also.
Oh.
Cell number 3. Cell number 3, O my Girish B. Bandare. Gangadhar Sangoli.
No representation for the appellant. List this matter for the dismissal. Give a date.
Yes.
Hmm? Give all these matters on Saturday.
22. Cell number 4.
This also, no representative. The other matter also, give on Saturday, one, no representation for dismissal.
Yes, ma'am. Please.
This matter also, Mr. Mahesh, 4 also for
Yes,
dismissal.
and for the respondent.
Yes,
Cell number
on Monday,
5.
on Saturday,
Please, yes. Cell number 5.
for dismissal on Saturday.
Cell number 6. Suresh
Madam.
M. Latur.
Yes, Mr. Latur. This also for dismissal on Saturday.
Cell number 7.
My lord, I
Cell
appeal
number
and
7, Umesh B.S.
some accommodation may granted, my lord. Next week, my lord.
Why all the matters adjournment, Mr. Umesh?
My lord, today I'm in the parted matter, my lord. I'm sorry. Otherwise, otherwise I am all right, my lord.
Appearing for this.
It's not comfortable. I'm like, all these final hearing matters, why do you
I
ask for
understand, my
time?
lord. Some short
And
accommodation.
then other matter, you come in the afternoon. Come in the afternoon.
My lord, in the matter,
my lord.
my lord, kindly see the order sheet. My lord,
That's what we'll not grant. That's what I'm saying. Pass over. Yes.
Also, cell number 8.
For appellants, my lord. My lord, may be taken on Saturday, my lord. I'll argue with the matter.
Saturday.
Cell number 9.
Ready, ma'am.
Kalyanar.
2 matters, ma'am. My appeal, we are ready. If he comes, I'll be here only, ma'am.
Pass over.
Cell
For
number-
Saturday, give some list because there are no other matters. If your matters are there.
I have
give the
given
list.
one full list, my lord, that.
Then those matters. you
ನಾ
list
ಕೊಟ್ಟಿದ್ದೀನಿ
down.
ನಾನು.
Our junior is
ಹಾ.
not given.
ಕಲ್ಯಾಣ.
Not there, I have been provision.
Oh, okay.
No, if they give the list, give it to the section so that they have to pick the bundles. All that because no matters are there. On Saturday, post only these matters, the MFA matters. Yes.
Cell number 10.
Here for the
Bala
responding
Kumar.
one.
This
Ready, ma'am.
also,
Bala Kumar
this
for
also
appellant.
Saturday.
Yes, ma'am.
Other side is not there, no representation for the appellant for dismissal on Saturday.
Cell number 11.
For the respondent number 182.
Yes.
Ready.
Veena HR for appellant.
Which one?
Number 11.
Where is Veena Hitcher?
Lord, she's my colleague.
Jan Davis.
Yes. Yes. Claimant's appeal.
Claimants appeal.
Payments.
What is the amount claimed?
10 lakhs.
What is the amount granted?
No amount has been.
No amount, dismissed.
It's been
Petition is dismissed. On
Dismissed.
what ground?
Now, I don't know.
Lord, it's been dismissed on the grounds that there has been, the court disbelieves that an accident has actually taken place.
Accident itself is disputed.
Yes.
Lord, in the instant case,
Or shall we pass over?
kindly pass on.
Yes.
Pass on. Cell number 12,
This,
12, V.S.
this,
Umesh.
this might kindly be called next week. Otherwise, I'll train the
We'll
other
give a
matter.
matter next week.
Please.
Give a date.
Cell number 26, 4. Cell number 13, Anant Narayan, VN.
No, what is urgency for a 2024 matter when all other MSAs are pending? Why they are listed for final hearing?
It is a date given matter and some of them have been.
Pass over, my lord.
You appear for whom respondent?
Respondent.
Where is the counsel for the appellant? Appellant.
13, Anant Narayan, VN.
Anant is not well. Yes, he is admitted to hospital. So next week.
Submitted that the counsel for the appellant is unwell. List this matter after 2 weeks.
Please.
Yes,
Cell
14.
number 14, Vivekanand.
No
Anthony.
representation, no representation, post after 4 weeks. Any matter pass over ready?
Passover matters.
List number 2.
22.
My respectful submission to lordship is
Hmm.
a suit filed by the R1, that is respondent number 1.
Counsel for petitioner.
Huh.
See, one of the advocates' wife has expert morning. There, he will come up to 2:30.
Oh, this is they are not ready. They asked for a passover. Where both sides are ready.
Both are real.
2:30.
That's what.
Both
Where
counsels
both sides are ready.
in Passover matters.
2:30, I'll come, my lord. 10569. He'll come at 2:30, my lord.
Ready, both the sides.
Both of you are ready?
Yes,
Ah,
ready.
which
Serial number 11, list 3.
7.
Yes.
My lord, the accident that has taken place on 26th of May 2000.
What we'll do is, we'll straight away go to that particular paragraph
Yes, my lord.
and then you can make your submission.
Yes.
Come
And
to
then-
this reasoning part.
Lord, beg your pardon.
Reasoning part, issue
Yes.
number 1.
My lord, the issues that were framed were at page number 20 of the paper book. Whether the petitioner proves that he has sustained injuries in a road traffic accident dated 26/5/2014 at about 4:30 p.m. in front of Sony Sticker Cutting Shop, Mutton Market Road at Hassan due to the rash and negligent riding of the rider of the bike bearing registration number so-and-so by its rider as alleged in the petition. 2, whether the third respondent proves that the rider of the offending vehicle did not possess a valid and effective driving license as on the date of the accident, and the owner has violated the policy condition. 3, whether the petitioner is entitled for compensation. If so, what quantum and from whom? 4, what order or award? My lord, the issue numbers 2, 3 have been answered with does not arise because issue number 1 has been answered in the negative. And this issue number 1 has been answered in the negative, my lord, because the trial court.
You can read.
Yes. Issue number 1. As per the allegations made in the petition that the accident taken place on 26/5/2014 at about 4:30 p.m. in front of Sony Sticker Cutting Shop, Hassan, it was due to the rash and negligent riding by the rider of the bike bearing number so-and-so. The complaint is lodged on 27/5/2014. Case is also registered and the investigating agency have submitted the charge sheet against the rider of the bike bearing number so-and-so for an offense punishable under section 279, 337, 338 IPC. read with section 187, 181 of the MB Act. Here, the respondents are seriously disputing the cause of the accident and the reasons for sustaining injury by the petitioner. It is their contention that while admitting the petitioner for treatment, the history of injury given as fallen from height. Then, in connivance with the medical officer of a private hospital and also with the police officers, lodged a false complaint to gain illegally. Now, the tribunal has to appreciate the existing fact to know the cause of injury, whether it was due to the accident as alleged or due to fall from height as alleged by the respondents, and also recording in the hospital MLC register at the first instance. To prove the said aspect, the petitioner adduced evidence by filing the affidavit, and he got marked documents Exhibit P1, the copy of FIR. Exhibit P2 is the complaint. Exhibit P3 is a copy of a charge sheet. P4 is a copy of the Spart Mazer. P5 is the copy of the seizure Mazer. P6 is a wound certificate. P7 copy of the IMB report. P8 is a police intimation, and P9 is the OP slip. The petitioner in his cross-examination admitted that immediately he was admitted to Government Hospital Hassan, but he denied regarding giving any statement as if he falls from height. PW2 is a medical officer and has given treatment by conducting surgery at Janapriya Hospital Hassan. This is the hospital to which he was taken subsequently. PW3 Mustaq deposed as if he witnessed the accident caused by the rider of the bike on 26/5/2014. PW1 and 3 are denying the suggestion as if the petitioner sustained injury due to fall from height. The respondent led the rebuttal evidence. RW1 is the respondent in this case. RW2 is a development officer of the third respondent, insurance company. They had produced documents. Exhibit R1 is the wound certificate issued by the doctor of SC Hospital Hassan. This is the government hospital, wherein the history of injury mentioned as fall from height and nature of injury recorded as simple in nature. Exhibit R4 is the MLC register extract, wherein it is recorded that the father of the injured by name Fiaz, he is not a witness examined in this case, where the father of the injured by the name Fiaz admitted him to Government Hospital Hassan, wherein he has given the information self fall from height at 4:45 p.m. on.
I've seen the entire.
Yes.
What are your submissions?
My lord, my submissions are these, my lord. My lord, if your lordship would kindly turn to Exhibit P9.
Yes. Who has admitted you to the hospital?
Lord, this is it.
According to there are two versions. According to you, according to your version, it is your father on one hand.
Not
And
my
PW3 says,
that
who
he
is
has.
your friend?
Yes, he is the one who has
He
admitted.
has admitted
Yes.
admitted in the hospital.
Yes, ma'am.
Now, in the MLC register, which is the information at the first time when you are taken to the hospital,
Yes,
when it contains that it is a fall from a height, what steps you have taken to correct those MLC register?
Kindly see Exhibit P9, the MLC register.
Yes.
The lordship will find on the right-hand side of the page, 26/5/2014, history of road traffic accident, HO, history of road traffic accident at 4:30 p.m. on 26/5/2014, hit by a bike when a patient was crossing road at near Mutton Market. My lord, Exhibit P9 itself says that he was hit by a bike. This is given by.
Where from the court is
SC.
inferring about that fall from the.
This is
height?
given by SC Hospital, Sri Chamarajendra Aspatre, Hassan. This is the MLC register extract itself.
No. Then where from the court infers that?
R1 and R4.
R1 and R4.
Exhibit R1 and R4, which I have produced.
His father subsequently comes and says that, look, my son has fallen from a height, but he has been admitted to the government hospital itself.
No. Take out Exhibit R1. Exhibit R1 is given by whom?
It's a wound certificate given by the government doctor of the government hospital.
This is the wound certificate.
Exhibit R1 is
R-
the wound certificate.
Wound certificate.
Wound certificate.
Where do you get that fall
This
from height?
certificate, your lordship will
Wound
find that it's
certificate is
dated on
dated-
5/11/2014.
5/11/2014.
The
Now-
accident happens in the month of May 2014.
And
In that
your,
wound certificate,
one minute. That exhibit, what is that we have seen just now, P
P9, my lord.
dated
That is dated 26/5/2014,
26?
5/2014, the date of the accident.
Then why this is
Precisely.
given on 5/11/2014?
My lord,
My lord,
5/11/2014,
kindly
they
come
have
to
taken it
R4, my lord.
subsequently.
MLC register, R4.
R?
Exhibit R4.
There is that. Why, how can there be two MLC registers?
My lord, one is the wound certificate.
No, MLC register.
MLC
What he is
Wound
pointing
certificate
at-
has to be extracted from the MLC register. There is an MLC register. Any number of extracts can be given to a patient.
This is R4. Oh,
Is this the same document?
this is given when?
This is given on 5/11/2014.
Huh.
My lord, it reads over there. In the top, it says, of course, your lord, most of it is in Kannada. It says Mohammed Gauss. This is a Gayada Pramana Patra, wound certificate. It should have been extracted from the MLC register. But this is what they have done. They say here that it is a male, Gandusu, Mohammed Gauss, son of Fayaz, 21 years.
Same hospital.
Yes.
It's the same hospital.
Yes.
Now, first MLC register, it is shown that he was hit by a bike. Now, very same hospital.
My lord, SC hospital is the government hospital. Janapriya hospital is a private hospital.
But the first wound certificate was given by SC hospital.
My lord, may I peruse because my lower council did not give me the LCR. May I
You
just-
hear? Because court, there is no whisper about this by the court about exhibit P9. Now, when there is exhibit P9 and you're denying and something is wrong with that, you should have examined a doctor in support of that or the hospital.
Lord, it is dated 26/5/2014, accident date. And reason is self-fall from height at 4:45 PM on 26/5/14.
Oh, how can there be two different MLC, basing on MLC only, the certificate would be
Yes,
issued.
Lord, I will just.
MLC, look at the MLC, exhibit P9.
Exhibit P9, it should be on page 53, ink page.
Say, exhibit P9, show him.
One second. Exhibit.
P9.
It's totally unclear as to which patient it is referred to. There's no details of who is admitted. Who?
For giving a wound certificate, there should be a basis.
Definitely.
So there must
Very
be immediately once a patient comes with accident
Very well.
history,
Very
they'll prepare that, they'll enter all that into that
Very well.
register.
Very well.
It is, who is denying it?
But
There
this
is
is
no mention, there is no mention in the entire order
Lord, maybe the evidence, the deposition, if they have,
Not deposition, order should contain. Order should contain why the court is not believing exhibit P9.
P9.
And it is believing only R1 and R4.
Mhm.
What we'll do is,
Ah.
we'll set aside this order, we'll remand it. Whatever evidence you want to adduce, you can also adduce. Saying that exhibit R1 or exhibit P9,
Mhm.
nothing is written, it doesn't belong to him, it
Mhm.
belongs to somebody else.
Yes,
Leaving it open to both the parties,
Hmm.
raise all your pleas.
maybe expedited disposal within 1 month.
Please come. Agreed with the order passed in MVC number 15, agreed with the dismissal of MVC number 1577 of 2014 dated 8th February 2016. The claimant is before this court. The claim petition is filed under section 166 of the Act, Motor Vehicles Act, claiming compensation of an amount of rupees 10 lakhs for the injuries sustained by the claimant in the road accident that took place on 26/5/2014. The facts of the case are that on 26/5/2014, at about 4:30 PM, in front of Sony sticker cutting shop of Old Mutton Market, Hassan, the claimant was proceeding towards the chicken center. While crossing the road, the rider of the bike bearing number KA 13 EC 3221 rode the same in a rash and negligent manner and dashed against the claimant. In the result, he has sustained injuries. He was admitted to Janapriya Hospital at Hassan, where it was found a fracture of right tibia and fibula. He was undergone the surgical operation and spent an amount of rupees 1 lakh. The insurance company has filed their objections. And they have denied the accident and that the rider of the motorbike not possessing a valid effective driving license. The court had framed 3 issues. With regard to the issue number 1, that is whether the petitioner proves that he had sustained injuries in a road traffic accident dated 26/5/2014 at about 4:30 PM. In 4:30 PM, the court had negatived the same. The reasoning given by the court is that to prove the case of the claimant, he has adduced evidence by filing the affidavit and he got marked exhibiting, he got marked the documents exhibit P1, that is FIR. Exhibit P2 is a complaint. P3 is a copy of charge sheet. P4 is a copy of the spot Mahajar. P5 is a copy of the Caesar Mahajar. P6
Your
is a wound certificate.
I'm sorry, my lord, sir. I wasn't aware that our matter is going on. Kindly, I may be permitted to submit my.
Yes.
No, this claim petition is dismissed. Based on, claim petition was dismissed based on the documents that is placed at.
R1 and R4.
Yes, my lords.
But what happened to exhibit P9 is the question. Exhibit P9 is the MLC register, which says that it's an accident. Look at it.
It says history of RTA at 4:30 PM hit by a bike.
And wound certificate says it's a fall from the.
Well, it's all fall from the
No,
bike.
Like, it has to be from the MLC. Already their first information with regard to the accident is there.
It says it's a road traffic accident, but the details as to regarding the manner of the accident is not being stated in the.
Not necessary. MLC need not contain everything.
My lords,
But the court has
Yes.
not at all appreciated exhibit P9. So what this court is going to do now is,
yes, my lord.
as far as this order will be set aside,
Yes,
as far as the exhibit P9 is concerned, if you deny that, you will adduce your evidence if you, whatever that is
Yes.
available to you, he will have his option
based
to,
on the recital in the wound certificate.
whatever
Yes.
it is, that,
Yes.
let the court decide it, because court has completely ignored exhibit P9 and only was looking at R1 to R4. What did you write? Exhibit P4 is a copy of the spot Mahajar. P5 is a copy of the Caesar Mahajar. P6 is a wound certificate. P7 is a copy of the IMB report. Exhibit P8 is a policy intimation and exhibit P9 is a OP slip. The court observes that the claimant in his cross-examination admitted that immediately he was admitted to Government Hospital Hassan, but he denied regarding giving any statement that he is fallen from height. PW2 is a medical officer given treatment by conducting surgery at Janpriya Hospital Hassan. PW3 deposed as if he witnessed the accident caused by the rider of the bike on 26/5/2014. And PW1 and 3 are denying the suggestion as if the petitioner sustained injury due to fall from height. The court comes to the finding that as per the exhibit R4, this itself is wrong. Exhibit R4 is not the MLC extract.
And one more thing, my lords, whatever the exhibit P9 your lordship were
No,
referring to.
exhibit R4 is
Yes.
not the MLC register.
R4
It is a wound certificate.
It is apagata vahi, means accidental
Accident,
intimation given by the casualty medical officer to the police, my lords.
But you can't call it MLC register.
It
In
is not.
fact, exhibit P9 is MLC register.
Exhibit P9, in fact, this is an initial medical record. Even this is also not an MLC register, my lords. And this P9 incidentally doesn't contain the name of the person for whom
But
it
where is the
pertains to.
discussion in the order?
My lords,
Where is the discussion in the order? Court has not at all considered exhibit P9 at all.
but P9 has been termed as MLC register, but it is not an MLC register, my lords.
It is not termed at all.
Yes.
As per the court, it is only a OP slip.
Yes, absolutely.
OP
my
slip
lords.
and no
It's an OP.
discussion on that.
Yes.
So whether it is MLC register or not, or what you say is an MLC register, both of you have your own option to adduce the evidence
Because
and just,
2014 matter.
but at the same time, court cannot ignore that fact. And this order on the first count needs to be set aside on the ground that how the court had dealt with exhibit P9.
Even it is not the case of the claimant that there is an error that has crept in his own medical records. And these are the medical records. which-
No. He's relying on exhibit P9. How
Yes.
P9 is wrong, and even he has examined the medical officer who said that he has been treated.
Yes,
He has been treated.
yes.
So the evidence of the medical officer read with exhibit P9, court should give a finding on that. No, this court is not
Whether
giving
it
any
agrees
finding.
or not otherwise.
The
Yes.
court
yes,
is not giving any finding
Yes,
on
yes,
whether it is right or wrong.
yes.
Court is only saying the court to examine, and if you
Both
any of-
exhibit P9 and other
in
documents
the light
relied
of
by.
the
Yes.
evidence and R1 and R4.
Yes.
And further evidence you want to let in, let in.
And to give a finding on all of them. Yes, yes.
What did you write? Exhibit R4, it is a fall from the height, but not a road traffic accident, and accordingly dismiss the claim petition, and no findings were given on other issues. Land counsel appearing for the appellant claimant submits that court had completely ignored exhibit R9, exhibit P9, which clearly shows that the claimant had sustained injuries in the road traffic accident. And it is submitted that exhibit R4 is not a MLC extract, but the court termed it as an MLC extract, and without considering P9, had given more credence to exhibit R1 to R4. And the medical officer who was treated was also examined. Even his evidence was not considered.
It is MLC intimation, my lord. Apagata vahi, it is MLC intimation.
No, was not considered. It is submitted. Now, MLC intimation will be basing on the MLC register.
Yes, yes, my lords.
It is submitted that the R4 runs contrary to exhibit P9, and there is clear the lapses on the part of the court in appreciating the evidence, both the oral as well as the documentary evidence. Next parallel, counsel appearing for the respondent insurance company submits that the trial court had rightly considered, and considering exhibit R4, which shows that it is a fall from the height, had rightly dismissed the petition, and there are no grounds to interfere with. Next part. Having heard the counsels on either side, produce the entire material on record. The whole dispute is with regard to, according to the insurance company, as per exhibit R4, he has sustained injuries as he has fall from a height. According to the claimant, basing on exhibit P9, he has sustained injuries in a road traffic accident. When the court is considering this evidence on behalf, adduced on behalf of both the parties, the court ought to have considered exhibit P9 and in the light of the evidence of the doctor, the medical officer, and also exhibit R1 and R4. It appears from the entire order that court had given more credence to exhibit R1 to R4, and the R5 is not R9 is, P9 is not considered, and it's proper, is not considered. In that view of the matter, this court deems it appropriate to set aside this order and remand the matter back to the trial court. Accordingly, the following: 1, the so-and-so is set aside and the matter is remanded back to the trial court. This court is not expressing any opinion on the merits of the matter. The fact that the court has not considered exhibit, there is no discussion about exhibit P9, and the evidence of the medical officer. Now the matter is remanded back to the trial court. Next, number 3. Both the parties are at liberty to adduce any evidence with regard to in support of exhibit P9, R1 to R4. Basing on the evidence that is latent, the court shall pass appropriate orders. Next, without further notice, both the parties shall appear before the tribunal on 15th of April.
Yes.
15th of April, and within 6 months from thereon, the court shall pass appropriate orders.
3 months, my lord. Then.
No?
Can it be 3 months?
Months won't be possible. Yes.
Much appreciated.
Obliged.
Medical.
Yes, that remand matter.
So it's
You want to file your wakalat, then orders needs to be passed.
So that impleading application may be allowed, man. Impleading application. So our name will be showed. I will file the wakalat and
This is
serial number, sir.
Serial number 11.
Serial number, list number 2, serial number 11, my lords. My lord, one submission. My lord, I have filed a similar case, similar MSS. It may be connected together.
Serial number 11, IN number 2 of 24 is filed to implead the beneficiary. It is stated that before the reference court, the beneficiary is not impleted. Accordingly, IN number 2 of 24 is allowed by impleading so-and-so. Learned counsel, Mr.
BR.
Prashant BR takes notice on behalf of the implead respondent number 2 or 3.
2.
Implead
Proposed.
respond,
Yes, clear, 2 minutes.
respondent number 2. List this matter along with so-and-so.
Yes, I shall give the list.
Give a date. Give a date next week.
27/3.
Yes.
Please.
You, what is it? So-and-so takes notice for R1. Yes.
Please.
Sorry for the, because.
I'm not able to hear. Please use the mic.
Sorry, my lord. I was engaged in some other court.
Which case?
In serial number 8 of the list number 3, my lord.
Serial number 8.
8.
Uh,
It is posted for the dismissal, my lord. I am for the respondent.
uh.
It is posted to 22nd. Kindly have it on Monday because Saturday I am not available. That is my sincere request.
Yes. Give the date.
Okay. Serial number.
Yes.
My lords, list number 2, serial number 1, my lords. Sincere apologies, my lord, we could not appear in the
Virupakshaya.
yes, my lords. I do not have the file with me, my lords.
What is your senior's name?
Dore Raj.
Huh?
Dore Raj.
PM Dore Raj.
Yes, ma'am. Yes, my lords.
Monday.
My lords, tomorrow, my lords.
Tomorrow.
My lord,
serial number 2, list number 2, serial number 1, my lord, appear for
Madam,
respondent.
Huh?
Appear for respondent, my lord.
List number?
2, serial number 1.
Tomorrow it will come.
Tomorrow. At
Much
which
obliged, Lordship.
My Lordships, list number 2, serial number 23. I withdraw all the petition.
number 2?
Serial number 23, Sunil S. Narayan.
List number 2, serial number?
23, my Lordship.
You want.
My lord.
Memo is filed seeking to withdraw the petition. The same is taken on record and is permitted to withdraw the petition. Yes.
With your
My lord, list number 3, my lord, serial number 14.
Yes.
Can it be had on Monday, my lord?
Serial number 14.
Not Monday. Monday is not possible. Give 2 weeks time. Yes, 2 weeks. Yes.
Any date may be fixed, my lord.
Yes, they'll give the date. You'll get
Okay.
it. Yes.
Kindly, my lords. List number 3, serial number 3, as the land counsel for the appellant did not appear, the matter is taken up for dismissal on Saturday. Morning, I had a conversation with him regarding the possibility of settlement. We arrive at a figure and pass it on to this honorable court. So it may be taken up next week. By that time, I'll take the approval of the company, my lords.
I'll sign it, anyhow,
Yes.
because all these changes have to be done.
Serial number 14, my lords. Serial number 14, list number 2. Date may be given, my lords.
List
It is passed over.
Why did the day should be given in a passed over matter?
My lords, with regard to that criminal miscellaneous, which I have, which has to be transferred.
Anna, how can they give? No,
My lords,
there is no date. Why they have numbered it? Will, anyhow, I'm going to dismiss it.
my lords, I'll also inquire with that, with regard to that.
We'll pass orders in that.
Serial number.
Madam.
Court officer, madam.
Three.
Court officer, madam.
3, madam, Girish Baldar.
Dismissal ಬೇಡ.
ಬೇಡ on 3-4.
ಮತ್ತೆ ಇದು serial number 8.
Serial number 8 ಅಲ್ಲಿ at request
ಯಾರು?
of respondent counsel on 7-4.
So dismissal ಇಲ್ಲ.
ಇಲ್ಲ. ಯಾವ್ದು?
Madam, 3.
My lord,
Three ಹೇಳಿದ್ದೀನಿ.
madam, serial number 14 in list number 3.
ಯಾವ್ದೋ ಒಂದ್ ಒಂದ್ dismissal.
ನಾಳೆ matter ಯಾವ್ದು ಹೇಳಿ ಮೇಡಮ್? ನಾಳೆಗೆ ಒಂದು.
ಸರ್ ಇದು 2 weeks ಡೇಟ್ ಕೊಡ್ತೀನಿ. 1 ನಿಮಿಷ ವೇಟ್ ಮಾಡಿ.
ಯಾವ್ದು ಮೇಡಮ್? ನಮ್ದೇನಾ?
ಇದು
10-4 ಕೊಟ್ಟಿರೋದು. 14 ಕೊಡಿ. 10-4
Number 3, serial number 9.
15-4. Sir, your matter is on 15-4, sir. Serial number 14 in list number 3.
15th.
15-4.
Okay. ಆಯ್ತು.
ಇದೊಂದು dismiss. ನಾಳೆಗೇನೆ ಅದು ಡಿಸ್ಮಿಸಲ್ ಅಂತ ಬೇಡ. ಅದು ಅವಳಿಗಾಗಿರೋದು ಅನ್ಸುತ್ತೆ. ಇವಳಿಗೆ ಇಲ್ಲ ಲಿಸ್ಟ್ 2 ನಲ್ಲಿ.
ಮೇಡಮ್ 2:30.
What else, sir? What else, sir?
ಅದು at request ಅಂತ ಮಾಡಿ. At request of counsel for the petition ಅಂತ. ಒಂದು ಅದು no representation at the request of counsel for the petitioner. So this matter on 21. ನಾಳೆಗೆ
ಮೇಡಮ್ ಇದು ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 11 ಬೇಕಿದು ಪಿನ್ ಮಾಡಬೇಕು ಅಲಾಂಗ್ ವಿತ್ ಸುಮಾರು ನಂಬರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದೇ ಅವರು
ಲಿಸ್ಟ್ ಟು ಲಿಸ್ಟ್
ಲಿಸ್ಟ್ 1 ಸೀರಿಯಲ್ ನಂಬರ್ 11 ಅಲ್ಲ ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 11 ಈಗ ಮೆನ್ಷನ್ ಪ್ರಶಾಂತ್ ಬಿಆರ್ ಎಲ್ಲದರಲ್ಲೂ ಅದೇ ಸೀರಿಯಲ್ ನಂಬರ್ ಪಾಸ್
ಅಲ್ಲಲ್ಲ ಇದೊಂದು ಮಾತ್ರ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದಾರೆ ಬೇರೆದೆಲ್ಲ ಇಲ್ಲ ಲಿಸ್ಟ್ ನಂಬರ್ ಅದ್ರಲ್ಲಿ 2 ನಲ್ಲಿ ಇದು ಬೇರೆದೇನು ನಿಮ್ಗಾಗಿಲ್ಲ ಒಂದ್ರಲ್ಲಿ ಇದೊಂದ್ರಲ್ಲಿ ಮಾತ್ರ ಅವ್ರು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದಾರೆ ಬಂದು ಒಂದ್ ನಿಮಿಷ ಇದೀಪ ಒಂಚೂರು ಅಡ್ವೊಕೇಟ್ ಕ್ಲೋಸ್ ಮಾಡ್ತೀನಿ ಇದು ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಟ್ಟು 5 ನಿಮಿಷ ಆಮೇಲೆ ಮಾಡಿ ಎಲ್ಲ ಚೂರು ಫೈಲ್ಸ್ ಕೊಟ್ಬಿಡ್ತೀನಿ ಅವ್ರಿಗೆ
What of sir?
ಇಲ್ಲ ಹಾಕಿದ್ದೀನಿ ಪಿನ್ ಆಯ್ತಾ ಅಲಾಂಗ್ ವಿತ್ ನಂಬರ್
ಇಲ್ವಾ
ಇತ್ತು ನಂಗೆ
ಫೈಲ್ ಇದೆಯಲ್ವಾ ಅಲ್ಲೇ
ಇಲ್ಲ ಇಲ್ಲಿ ಇತ್ತು
ಹೇಳಿ ಏನ್ ನಂಬರ್ ಅದು ಹೇಳಿ
ಸುಮಾರು ನಂಬರ್ ಹಾಕಿದ್ದಾರೆ ನೋಡಿ ಇಷ್ಟು ನಂಬರ್ ಹೇಳಿದಾರಲ್ಲ
ಕೊಡಿ. ಯಾವತ್ ನಾಳೆಗ
ನಾಳೆಗಲ್ಲ ಮ್ಯಾಮ್ 27
ಯಾವ್ದು ಅದು
ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 11
ಅಲಾಂಗ್ ವಿತ್ MSS 172 24 ಇವರು ನೋಡಿ ಕೇಸ್ ಕರ್ತಾಗಿಲ್ಲ ಇವಾಗ ಕನೆಕ್ಟ್ ಆಗಿದ್ದಾರೆ ಓ ಮಹೇಶ್ ಸರ್
Court officer? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಏನು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
ಹೇಳಿ.
ಇದೆಯಾ ಮೇಡಮ್ ಸಿಟ್ಟಿಂಗು?
ಇದೆ ಸಿಟ್ಟಿಂಗ್ ಇದೆ, ಬರ್ತಾರೆ ಮೇಡಮ್.
ಓಕೆ ಓಕೆ ಸರಿ ಸರಿ ಮೇಡಮ್, ನಂದು ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 22 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ.
ಕರೀತಾರೆ ಮೇಡಮ್.
ಹಾ, ಥ್ಯಾಂಕ್ ಯು.
ಹೌದಾ? List one serial number 11. List two ನಲ್ಲಿ 15. List two ಅಲ್ಲಿ ಯಾವುದು ಇಲ್ಲ. 15 and 20. ಅದೇ 15 ಮತ್ತೆ 20. 11. List two ನಲ್ಲಿ 15 and 22. List two 3 ನಲ್ಲಿ serial number 9, 7 and 9. ಹೇಳಿದ್ರ ಮೇಡಮ್ಗೆ ಎಲ್ಲ ಈ ತರ ಮಾಡಿಸ್ಕೊಂಡು ನೀವು ಇಲ್ದಲ್ಲಿ ಏನಂದ್ರು ಮೇಡಮ್? ಇಲ್ಲ ನಮ್ ಕೋರ್ಟೆ ಅಲ್ಲ ಮೇಡಮ್ ಅಲ್ಲ Pass over matters. List one serial number 11. NK Siddeshwara.
I'm sorry, my lord, in the morning I could not.
Which one with serial number?
7. List one serial number 11.
Lord, this is an appeal by the owner of the vehicle. Lord, the May City, Lord, fixed a liability against the owner of the vehicle solely on the ground that, my lord, my driver license was expired. That was renewed subsequently. Solely on that ground, my lord,
But anyway, you were not having a driving license as on that day. What else you
But
want?
as per the, my lord, Honorable Apex Court
Let's see, is it
citations,
that?
yes. It is not a fundamental breach and pay and recovery was ordered in this.
How is it useful to the owner?
Yes, my lord, the insurance companies, anyhow, my lord, there is no dispute with regard to policies, my lord, he was in force.
No, pay and recover, that is the problem of the claimant.
He is banking on us. Generally, he's banking on the insurance company's slackness in not proceeding.
Because I can understand
Yes,
if
yes.
the claimant has come to the court and said, it should be pay and recover. As far as you are concerned, it shouldn't make any difference.
But
Because
yeah,
ultimately you are the one who has to pay.
that is the reason. my
Pay
lord.
and recover will come to
not
the
make-
rescue of the claimant,
Yes.
not you.
But I
Well,
think
in the identical case, my lord, why it was owner against that, that order is, my lord, is against the owner. My lord, that he has challenged before the Honorable Apex. Subsequently, my lord, the Apex Court has held, my lord, pay and recovery was ordered. That is, my lord, it's a very short judgment, my lord. This paragraph 7, in the present case, owner of the vehicle did not contest the proceedings and prove and establish that in spite of the best efforts, the fact that the driver did not have a valid driving license was not known to him. What alone stood proved by the insurer was that the driver of the vehicle did not have a valid driving license on the date of accident, as the driver had a license, but validity of the same has expired.
Consideration in this.
Because, my lord,
There are judgments where the issues were considered and orders are.
yes, another judgment, division bench of our Honorable High Court judgment, my lord, that is also entirely the issue was considered. My lord, merely because, my lord, the license was expired. My lord, paragraph 23, 24, 25, 30, 31. My lord,
Paragraph number?
paragraph number 23, it starts, my lord, finding. Class 6 of summation is relevant. It is stated that even where there is insurance is able to prove breach on the part of the insured concerning the policy condition regarding holding of a valid license by the driver or qualification to the driver during the relevant point of time, insurance would not allow to avoid its liability towards insured unless the said breach or breaches on the condition that the driving license is or so fundamental as to found to have attributed to the cause of accident. The tribunals in interpreting the policy conditions should apply the rule main purpose and concept of fundamental breach to allow defenses available to the insured under section 149(2) of the Act. A reading of the same would imply that the every breach of the policy condition regarding license would not ipso facto be so fundamental so as to enable the insurance company to avoid its liability. The breach with regard to conditions of possessing a driving license must be so fundamental so that have attributed to the cause of accident. Thus, there must be an nexus between the absence of valid and effective driving license by the driver of the offending vehicle and the accident. The same would imply the driver of the offending vehicle is not duly licensed to drive the vehicle, and in the absence of possessing the skill to drive the vehicle, has driven the same in a rash and negligent manner. It could also be a case where the driver is disqualified for holding or obtaining a driving license, and during the period of disqualification has driven a vehicle in a rash and negligent manner and caused the accident. Therefore, the aforesaid observation of the Honorable Apex Court in the context of expression used section 49(2)(a) 2 of the Act. Applying the paragraph 24, 24. Applying the aforesaid decision to the instance case, it is noted that the driver of the offending vehicle had the license to drive non-transport vehicle for a period from 24/7/1998 to 23/7/2018. He also had authorization to drive transport vehicle for a period from 3 to 2019 up to 2012. The license to drive a non-transport vehicle was renewed on.
I have no issues, my lord. Pay and recovery, I am also satisfied. I am only telling that delay of 1,509 days. That period I will not pay the interest, let him pay the interest.
Yes,
He is also agreeing to that.
the appellant is ready to.
How is it going to make the difference? Pay and recover.
My lord, for him, it might not make a difference. Usually, my
The
lord,
claimant is not before this court.
claimant is not before this court, my lord.
If claimant is there is no difficulty in ordering it. Now the owner is before this court. Ultimately, he'll pay. You have to recover from him.
I will have to
So what
recover.
is the order that he wants from this court?
Now he wants a pay and recovery order, which I am also not declining.
There are some judgments in that effect.
Yeah.
When this question of pay and recover comes.
Usually when the owner comes, it does not come.
It won't. You have no objection.
I have no objection.
Please come.
That only thing is, my lord, we have also agreed that there is a delay of 1,109 days.
Condoned.
The delay is condoned, but that period interest he has to bear, my lord.
Oh, was there any conditional order on that day?
My lord, that day, my lord, this was not.
But unfortunately, when it is without a condition condoned, that condition we can't impose it now.
So 3.5 years delay. my lord.
But you should have raised that at that point of time.
I have filed detailed objections.
But the order is passed long back, condoning the delay without any conditions.
That the one.
No, because
some-
delay
that-
is condoned without
that
conditions.
I do appreciate.
At
my lord,
this point of
but
time, you cannot
that-
do it.
That benefit may be kindly be given, my lord, because I'm accepting, virtually I'm
It will
accepting.
be very difficult in the further cases, sir, if the court gives such an order. Agreed with
Because
the
he is
order.
also conceding to that fact. He is accepting.
My lord, initially I told my client,
He's
there is a
accepting
delay,
that fact.
that amount, the interest has to be.
But even
paid
if
by-
both of you concede also, court cannot pass
Lord,
such
please,
orders.
please,
No,
please.
my
Agreed
lord,
with the order, which
my
is
lord-
MBC,
my lord may say on, after,
MBC number.
MEC number, my lord,
my lord may kindly say that.
MEC 15 of 2013.
Agreed with the orders passed in MBC number 15 of 2013, dated 28th day of June 2015. The claimant is before this court. The owner of the vehicle is before this court. The court, on the ground that, as on the date of the accident, the license of the driver is expired. The court had held that the insurance company is not liable to pay the compensation and directed the owner to pay the compensation of an amount of rupees
3,95,000.
3,95,000.
740.
740. 740?
It's 6% interest.
No, 740.
Yes.
There are
Against
two
the-
MBCs, that's why I'm asking. An amount of rupees 3,95,740. And the interest was at rupees 6% per annum. Land counsel for the appearing for the owner of the vehicle submits that in the law laid down by the apex court in case of Francisca Lucia Rocha and others versus K. Valar Mati and others arising, reported in year 2018 SC supplement 1440. Even in such cases also, insurance company is liable to pay the compensation. And record the same from the owner of the vehicle. Land counsel has also relied on another judgment of this, judgment of this court in Nagappa and others versus Ravi Uppaluru and others arising out of MFA number 10368 of 2015 and MFA number 103681 of 2015 dated 8th February 2019. Basing on this judgment, and counsel submits that the pay and recover principle will apply. Land counsel appearing for the respondent insurance company do not dispute the ratio laid down in the above referred judgments. Considering the same, the appeal of the appeal filed with the owner of the vehicle is partly allowed, and it is held that the insurance company is liable to pay the compensation awarded by the court and record the same from the owner of the vehicle. Yes, next.
Amount in deposit make.
Amount in, why amount, oh, yours
I have paid here also and also trial court also.
shall be forthwith transmitted to the trial.
That delay aspect may be
Because it
for-
is not
for
right
this-
on the part of the court.
Madam,
When while condoning the delay, when no condition even is
True, madam.
imposed.
For this reason, madam, my long standing it'll cast some. I'm sorry.
Only 2018 appeal.
My lord, no, my lord, the delay is 1,109 days. Please, my lord.
We should have opposed it at that time. Yes, next.
Serial number, list number 2, serial number 15.
I'm filing memo for withdrawal as it is not maintained.
What is that withdraw?
Memo for withdrawal.
Homo is filed, seeking to withdraw the petition. Accordingly, memo is taken on record, dismissed as withdrawn.
Serial number 22. Radha Jain, TCS.
I appear for the appellate, your lordship. Sorry, in the morning session, I couldn't come because of some personal inconvenience.
Where is the counsel for the respondent?
And
Yes.
for the respondent number 2, my lord.
What is this?
Yes, my lord.
Give the file.
This appeal is by the purchaser, wherein the first respondent was the holder of an agreement and he filed a suit for specific performance. It was decreed against the second respondent. It was decreed. The defendant therein, who is the second respondent herein, filed an appeal. Appeal also was dismissed. Therefore, the defendant, that is the JDR, was directed to execute the sale deed. So the plaintiff to whom the suit was decreed filed an execution, making the JDR also a party. After issuance of notice, JDR appeared through his counsel, but he did not execute any sale deed, my lord. Therefore, a commissioner was appointed. The draft of the sale deed was served to the JDR as well. He did not raise any objection. And by appointing a commissioner, the sale deed was executed in favor of the first respondent. Subsequently, the appellants herein have purchased it from the decree holder. When the matter stood, the execution petition also was closed. Later, the second respondent, who is the JDR, files an appeal before the district court and says that there are some irregularities and therefore the execution has to be reopened. The learned judge has reopened the matter, remanded the matter for trial again.
Let's see the appellate court order.
Yes, madam.
Page number.
I'll take, yes, madam.
Page number 9, my lords.
Read from the reasoning part.
My lord, it actually starts at para 17, my lord, after stating the facts. Page
Facts
80.
are also relevant. Let us read from there.
All right. My lord, from para 9, page 14 of my appeal memo, page 6 of the judgment order, my lord. Point number 1. The first question which needs to be considered is, what is the scope of the appellate jurisdiction of this court under 96 order rule 49, 41, Rule 1 of CPC while examining the order of the executing court passed under Order 21, Rule 34 of CPC. The learned advocate for the appellant has relied upon so-and-so, wherein it is held that the order passed under Order 21, Rule 22 of CPC amounts to decree under section 47 of CPC and is appealable as a decree, and it is not an appeal against the interim order but an appeal against a decree which is provided against the final order. The same analogy is applicable to the facts of the present case, and hence the appeal under section 96 of CPC is maintainable. The records disclose the respondent decree holder has filed a suit so-and-so and the suit came to be decreed, and the operative portion of the said judgment is as follows. Para 11, my lord. The JDR appellate challenged the said judgment and decree in RFA before the Honorable High Court of Karnataka, and the same was dismissed. The decree holder has deposited the balance sale consideration before the lower court. However, he has not taken any steps to execute the decree soon after the dismissal of RFA. He filed an execution petition before the lower court on 15/7/2014. Since he executed the said decree after 2 years of the date of dismissal of RFA, the lower court directed to issue notice to the appellant, judgment JDR. In spite of repeated issuance of notice, the same were not served on the JDR. Ultimately, the paper publication was taken and the JDR was placed ex parte on 7/9/2017. It is to be noted that the said procedure followed by the lower court is not in accordance with the rules prescribed under Order 21 of CPC. When an application is made more than 2 years after the date of decree or against the legal representatives of a party to the decree, the court must first issue a notice to the person against whom execution is applied for requiring him to show cause why the decree should not be executed against him. Further, the court has to follow provisions of Order 21, Rule 24 and 25 of CPC regarding process for execution. Rule 24 requires that in every case, a day specified on or before which the process is to be executed. In any case, the court cannot await the return of the notice after the day specified in the notice. Rule 25 makes it incumbent on the court to examine the officer executed with the execution and the process is not duly served to satisfy itself as records the reason for its non-execution and to record the result of its inquiry. If the courts make careful inquiry in such cases and do not blindly accept the reports of the processes before going to further steps like issuance of notice to
No,
substitute.
you are the judgment letter.
Yes, my lord.
The decree and the judgment and decree
Yes, my lord.
in favor of the decree holder has attained finality.
Yes, my lord.
What is your stand now? Why you don't execute the
Lord,
sale deed?
appellant herein has no locus standi. She is neither a party before the trial court, neither a decree holder. She claims, they claims that they are the purchaser from the R1, that is a decree holder. His sale deed was executed in the executing court. They claim that their sale deed was of the year 95.
No, that apart.
Yes,
that
ma'am.
apart, what they have done with the property is a different issue.
Yes, ma'am.
You have suffered a decree.
I have supported a decree, my lord.
Your duty, it's your duty to
My lord,
execute the same.
why the first appellate court came into my rescue was the proceedings and the procedure was not properly followed.
No, let's not go into the technicalities.
Yes, my
Let's look at this substantial
Yes, my lord. Yes,
issue.
my lord.
You have suffered a decree.
Yes, my lord.
That decree has attained the finality.
Finality, yes, my lord.
Why do you stop the execution?
No, I am ready to execute the decree, sale deed in the manner known to the law. I filed an application, 2 applications under order section 50.
When is the decree attained
The
finality?
decree was passed in 96, my lord. 1996 was the
1996 till now, you are not able to understand the proper way to how to decree to be executed.
No, it's not so, my lords. The execution was filed by the decree holder in the 2014 only.
We are in 24 now.
2007, I suffered RSA also, 2007. Execution was filed. Decree holder went on without getting
So
this.
what is the purpose you are going to achieve now?
Lord, I follow the rules according to the executing court.
Anyhow, sale deed is executed.
Yes, not yet. Sale deed is set aside, my lord. Your lordship, kindly.
No.
By the first appellate court.
If this court passes an
Yes,
order,
yes, yes.
it's again the same.
Yes, yes, my lord.
So why should that sale deed be set aside?
Why? Because, my lord, I was in an order 21 rule 22 mandates an party to notice to be issued to the JDR. As per the 21 rule 22, when notice is issued, as per 21 rule 23, I am supposed to and I need to be file objections. Suppose I have not filed the objections, recourse left for the court was 21 rule 34. And it is unknown to law in an executing court, a summons was served through paper publication. They
Because
claim,
it couldn't be served on you. Then what is the option left to the court?
Blood, the paper publication taken in one unnoticed paper publication.
No, here the issue is,
Yes, ma'am.
what is the prejudice that is caused to you by way of all the procedure? Ultimately, you have to execute the same
Yes,
deed.
yes, yes.
The same is being done.
Yes.
And why are you fighting for this?
Well, this is why I am fighting is this petition is not maintainable. Why? Because she is the objector before the trial court. Appellants herein are the objector before the
I'm
trial
not
court.
talking about this application.
Yes, madam.
I am talking about an application that you have filed before the court
Yes,
to
madam.
recall the order.
I
By all means, you have to execute the sale deed.
5024 was the judgment referred. RA was in my favor, madam. I challenged that order of execution of the and rejection of my right to file the objections and issuance of commissioner warrant to execute the sale deed. In a specific performance suit, madam, is proper to issue, it has to go as like that, malad. Under 21, malad, under 21 rule 34, if a direction is given to the JDR to execute the sale deed within specified date, he has to execute the sale deed. In the meanwhile, decree holder has to pay the draft sale deed to the court. Court in turn has to refer it to the other side, that is JDR, to make any correction.
I understand.
And that was not done. So, my lord, advocate commissioner was appointed. It is unknown to law, my lord. Advocate commissioner under.
Ultimately, what is the effect of that?
The effect is
how it is going to prejudice you.
It,
Either under what all the orders you are referring to,
Yes,
or
yes.
otherwise,
yes, madam.
you have to execute a sale deed.
Yes,
It
madam.
is not your case that
I
I have some other
I'm a
issue.
sufferer of the decree. It's
I have some other thing that I cannot, or no, either this procedure or that procedure, they have to, you have the
I will
sale
go
deed
by
have
that
to be
process.
executed.
Yes, yes, madam.
So why are you concerned now?
No, I'm not concerned, madam. Why? Because the appellant herein is not a proper person to challenge. R1, who has supposed to challenge that order, he filed an RFA that came to be rejected. It was dismissed. Subsequently, objector who filed application before the trial court in order 21 rule 96, 97 came before your lordship. One time they challenged that objector, they went in as an objector in the executing court, and now they are before your lordship supporting the judgment.
Was he before the appellate court or not?
No, she was not before the appellate court. She was an objector. She was later come before the executing court. She was neither the,
No, the order impugned, was she a party or not?
she was not a party, my lords. She was neither a decree holder nor a JDR. She was not at all a party. Lordship, I kindly peruse the
Come to the cause title.
cast item, my lords. Page number 9, my lords. Lingappa is an appellant JDR. Virendra Katoria is a R1 decree holder.
How come you cannot maintain an appeal like this?
Yes, my lord, here the decree holder, my lord, is no more interested in fighting the litigation in the executing court because he has already transferred his rights in favor of these appellants, my lord. He has no interest.
When was it?
In fact, I have, yes, ma'am. In fact, I have also stated a ground, my lord, that the decree holder and JDR are collusive. That is a ground that I have raised before your lordship. Because in the executing court, the decree holder doesn't come at all. He doesn't come forward and prosecute the case, nor does he defend.
Where did you seek the leave of the court?
Never.
How can you just like that file an appeal before this court? You not being a party before the
No, I am a party. Now I filed an application. I am the affected party, my lord. Now
Not here, madam, before when the impugned order.
No, impugned order, again, my lord, I was not aware of the impugned order.
Then what you're supposed to do? Straight away you'll walk into the High Court and you will file a
No, my
appeal.
lord, no, that because the decree holder, by mistake, to defeat my right or what, I don't know, had challenged this order in RSA deliberately. Deliberately. There I made an application, your lordship. There I made an application to get myself impleaded. There the honorable court has granted me a relief.
So because you are impleaded in a RSA, you will be straight away filing an MSA.
No, my lord. There the honorable court has given me liberty, my lord. I have filed a memo on 21/11/2024.
Liberty is, again, you have to come up with an application known to law.
No, yes, my lord, the honorable court, High Court has given me liberty, my lord.
Wrong submission. No liberty was given.
No, kindly come to the order passed in RSA, my lord, where I filed an application for impleading application. I have filed a memo with documents on 21/11/2024 at page 7, my lord, regular second appeal 161. The counsel for impleading applicant submits that she may be impleaded as appellant in this matter. But
where is the order? No, you are before this court. We are not concerned with all that. Please come to the impugned order.
No, my lord, the High Court has granted the relief.
Where is the High Court order?
High Court are produced with the memo, my lord.
You can come physically also to the court and argue all these kind of matters.
No, my lord, today my friend's wife passed away, my lord. That was, otherwise I would have come in the morning session itself.
Shall I read out that?
I am ready, my
what my
lord.
learned friend is. They have filed a memo on 19/11/24. They served the copy on me, my lords, with a memo. 19/11/24 with some papers and objections copies they filed. In that petition, page number 7. 7 is the judgment of the Honorable High Court in RFA number 161 filed by the decree holder, challenging the ARIA order.
RSA, my lord, second appeal.
RSA order.
Second appeal.
So challenging the ARIA.
Second appeal, if a liberty is given.
Not liberty.
Even in that case also, straight away you can't file an appeal. Even if a liberty is given, stating that you have to.
No, it is very clear, my lord, if the applicants have any independent
Shall
right,
I read out
they
the
can
judgment of
pursue the relief
what
by
my learned-
filing appropriate appeal.
That means you will straight away come and file. No.
Yes, my lord, that is, they've given me the liberty. They've given me the liberty
you're not
to
able to
file an
understand
appeal.
what the court is saying, then the court cannot help it. If the court given you a liberty, what you will say, you will seek the leave of the court to file an appeal. And in that appeal, you will say that in RSA also, you have been given permission by the court. Just like that anybody, because in some other proceedings, an order is, liberty is given. Where in an impugned order, you are not a party, how can you file?
Lord, submission.
Not in some.
Our civil proceedings are carried out.
No, my lord, not in some other proceedings, my lord. Against the same impugned order, my lord.
In that appeal, my lord.
Challenge, the
Impleading
challenge in
application
the
was
second
filed
appeal was the same order, my lord, not in some other proceedings.
Shall I read out
Against
the
the same-
operative portion, my lord, of that RFCA? They filed an impleading application before the court. Decree holder remains absent. Court were to dismiss that appeal. At that time, my lords,
Exactly, my
Page-
lord, the
page
decree
number 2 of
holder
the judgment, my lord.
doesn't file appropriate appeal. He colludes with the JDR. He doesn't support
is
me.
their
He doesn't
allegation.
defend me.
they only engage the respondent number
Therefore-
one lawyer.
Therefore, I filed an impleading application.
What
because
what
my
the
right-
court said, if the applicants have any independent right, they can pursue the relief by filing appropriate appeal. That doesn't mean that the liberty is given.
Not at all.
It is left to you.
No, my lord, he now decree holder will not do anything, my lord, admittedly, because he is no more interested.
Madam,
He has-
please understand, this is not the way we'll entertain the MSA.
No, my
And the
lord, it is a
provision
form-
invoked also, my lord, you doesn't say, it should, under 43 rule, one I and you, they are invoked.
Forget that. Just because in our RSA, court said whatever is the remedy available to you, so just like that you will come and, first of all, how this appeal is numbered is a big question now.
That is what matters.
No, my lord, what right locus has he got to do, my lord, to oppose my objection because he's been defeated. He's been defeated
First of all,
twice.
you tell the court, how can you file this appeal without the leave of the court?
My lord, that is a formal application. If your lordship insists, I'll make a formal application seeking
23 court
liberty.
has to advise you in 25.
No, my lord, because in RSA, liberty was given, my lord, that is why.
Adjourn this matter. The petitioner, the appeal as filed is not maintainable. Without the appellant not being a party in the order impugned, I cannot maintain this appeal. It is stated that in an RSA, they've been given the liberty. Even in that case also, they have to come up with an appropriate application. And basing on that, once the court feels that it is a case where the leave can be granted, then the leave will be granted to question the said order. But without any application.
My
how
lord,
the-
it's a
how the
formal
appeal is
application
numbered
permit.
is also
kindly-
known to the court. Yes, if whatever application the petitioner, the appellant wants, can come up with the same. Yes. Pose this matter after 4 weeks. Yes, next.
Serial number-
No trouble.
List number 3, serial number 7. List number 3, serial number 7.
Yes.
Before I start, the depositions, entire records are in Kannada.
Not, no, I can, you
Then
can
fine,
read.
fine.
Both of you can read, I can understand.
Please, madam, please.
Yes. Yes, you're questioning on what ground?
My lord, fraudulent implication of the vehicle.
Huh?
Fraudulent implication of the lorry.
So you're denying the accident itself?
Yes.
Please come to that portion of the order.
My lord, the accident has taken place on 7/1/2. In the judgment, my lord, it is
Issue number 1.
what the trial court says is, my lord, your lordship gets it at. There are 14, may I take?
Yes.
The official order company, namely Venkatesh, is examined, wherein in his affidavit in lieu of examination has not occurred due to rash and negligent driving of the insured vehicle as per the admission made by the first petitioner in CC number so and so, that her husband died due to ill health. RWN further states that the deceased Jagdish fell into pit on 6/1/2008 at about 1 PM due to his ill health and weakness, and immediately his colleagues brought the deceased to Jagdish to Kondli and left out him before house his own brother Prakash, and then deceased succumbed. But these facts were not pleaded in the written statement filed by the respondent. So as already
Let us
stated,
look at your objections. Take the file, take the TCR. Where did you say that the vehicle is not involved in the accident?
my lord, we have denied the accident, my lord. We have denied the accident.
See that.
We
You
have
have
denied
said that the driver is not having a valid driving license.
that we have stated.
Let's-
But we have taken the stand, my lord.
Let's see the objection.
Yes. We have denied the accident.
Paragraph number 4 of the written statement. 3 and
Para 5 ಅಲ್ಲಿ. The respondent does not admit and denies all the allegations that vehicle number was involved in the above alleged accident and found it was driven in a rash and negligent driving.
No, in the criminal case, the wife of the deceased has deposed that.
But it
her
is not a
husband
criminal case, but it is one
present
that
to the court
please.
has died due to ill health.
But it is not mentioned. But in the they have not produced the document.
No,
regard-
In this, they have said so. In their objections, they have said so. If you're denying, you should have filed your, to the rejoinder to this.
Please, my lord.
If you're denying, are you denying it?
Please, my lord.
Where is that? Is it part of?
Yes, my lord, I have produced it.
Where is that?
Exhibit,
Exhibit?
In the cross examination, he is denying the
That is, just like the denying can't help you when you have stated so in the criminal proceedings.
my lord, Exhibit R8 may kindly be taken.
Exhibit R8.
Yes.
Take it. This is deposition before the criminal court.
Yes, my lord, of the PW1.
Where is it?
My lord, may kindly take next page, my lord. On the bottom cross examination, my lord. ನನ್ನ ಪತಿ ಈಗ ತಿಂಗಳ ಹಿಂದೆ ನಿಧನ ಹೊಂದಿರುತ್ತಾರೆ. ನನ್ನ ಪತಿಗೆ ಆರೋಗ್ಯ ಸರಿ ಇಲ್ಲದ ಕಾರಣ ಅವರು ನಿಧನ ಹೊಂದಿರುತ್ತಾರೆ.
What does it
For a
mean?
moment, but kindly see, continue with this.
ಓದ್ತೀನಿ ಸರ್. ನನ್ನ ಪತಿ ಗಣಿಗಾರಿಕೆಯಲ್ಲಿ ಲಾರಿ ಕ್ಲೀನರ್ ಆಗಿ ಹೋಗಿದ್ದರು ಎಂದು ಹೇಳಿದರೆ ಸರಿಯಲ್ಲ. ದಿಸ್ ಇಸ್ ವಾಟ್ ದೇ ಸೇ. ದಿ ಗಣಿಗಾರಿಕೆ ಹೋದ ನನ್ನ ಪತಿ ಹೃದಯಾಘಾತ ನಿಧನ ಹೊಂದಿದ್ದರು ಎಂದು ಹೇಳಲು ಸರಿಯಲ್ಲ.
No, read the entire one. Read the entire one.
Yes, ma'am. My lord, this CC is between the claimant and my lord, the respondent, one in respect of a check bouncing case. And this is subsequent to the alleged accident. She had filed a case against him for recovery of some check bouncing case. My lord, there, my lord, all these facts have come out. And this is subsequent to the claim filing.
Read, where did she
Yes, ma'am.
accept that, that her husband died due to ill health?
My lord, that is a cross examination, clear admission. ನನ್ನ ಪತಿಗೆ ತಿಂಗಳ ಹಿಂದೆ ನಿಧನ ಹೊಂದಿರುತ್ತಾರೆ. ನನ್ನ ಪತಿ ಆರೋಗ್ಯ ಸರಿ ಇಲ್ಲದ ಕಾರಣ ನಿಧನ ಹೊಂದಿರುತ್ತಾರೆ.
It is denied is next continued.
Continue.
No, my lord. ನನ್ನ ಪತಿ
ನಿಧನ ಹೊಂದಿರುತ್ತಾರೆ ಎನ್ನುವುದು
ಎಂದು ಹೇಳುವ ದಿನ ಎಮ್ಮೆದೊಡ್ಡಿ ಗ್ರಾಮದ she has never denied that, my lord.
I will continue.
She gives a different version and says something else.
Mr. Raju, you please tell the court what.
Please,
is
my
that.
lord. Yes, I made a probably court doubts my illegal.
No, it's not that. What you are saying, he is denying it.
No, my lord, it is not.
He
I'm
is
sorry,
denying
I got
because
it.
court is not
I got it.
familiar with the language. So the third person who is not connected to that will tell. That's how they know way to understand
I'm
it.
sorry, I got it.
In future, sir, ಮುಂದಿನ ಓದ್ಬಿಡಿ sir ಅದು full. ಅದು ಓದ್ದೆ.
ಅದನ್ನ ಮೇಡಮ್ ಕೇಳ್ತಾರೆ.
ಕಂಟಿನ್ಯೂ ಮಾಡಿ ಸರ್.
ಈಗ 8 ತಿಂಗಳಿಂದ ನಿಧಾನ ಹೊಂದಿರುತ್ತಾರೆ. ನನ್ನ ಪತಿಗೆ ಆರೋಗ್ಯ ಸರಿ ಇಲ್ಲ ಎಂದ ಕಾರಣ ಅವರು ನಿಧಾನ ಹೊಂದಿರುತ್ತಾರೆ. ಫುಲ್ ಸ್ಟಾಪ್. ದೆನ್ ನೆಕ್ಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ನನ್ನ ಪತಿ ನಿಧಾನ ಹೊಂದಿರು ಎಂದು ಹೇಳುವುದು
ದಿನ ಎಮ್ಮೆ ದೊಡ್ಡಿ ಗ್ರಾಮದ ಶಾಂತಪ್ಪನವರು ತಮ್ಮ ಪತ್ನಿಯರ ಗಣಿಗಾರಿಕೆಯಲ್ಲಿ ಲಾರಿ ಹರಿದುಕೊಂಡು ಹೋಗಿರುತ್ತದೆ ಎಂದು ಹೇಳುವುದು ಸರಿಯಲ್ಲ. ಈ ಗಣಿಗಾರಿಕೆಯಲ್ಲಿ ಹೋದಾಗ ನನ್ನ ಪತಿ ಹೃದಯಾಘಾತದಿಂದ ಹೊಂದಿರುತ್ತಾರೆ ಎಂದು ಹೇಳುವುದು ಸರಿಯಲ್ಲ.
He denies that it is due to the accident.
Yes.
What she says, he died because of the,
Died due to illness.
but not
Full stop.
because of the road accident.
Full stop. And then the next sentence she says that I also deny that it is due to the accident. Adunu my lord, it is clearly mentioned in the paragraph, my lord, my husband was not dead
Before
due
starting.
to the
earlier,
illness.
deposition,
But it is a deposition and it is clearly mentioned.
Why, for the same thing, both of them are understanding in one way and you are understanding the other way?
ಆ ಎರಡನೇ ಸೆಂಟೆನ್ಸ್ ಓದಿ ಮೇಲ್ಗಡೆ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಪ್ಲೀಸ್ ಓದಿ ಅದ. ದಿನ ಎಮ್ಮೆದೊಡ್ಡಿ ಗ್ರಾಮದ ಶಾಂತಪ್ಪನವರು ನನ್ನ ಪತಿಯನ್ನು ಗಣಿಗಾರಿಕೆಗಾಗಿ ಲಾರಿಯಲ್ಲಿ ಕರೆದುಕೊಂಡು ಹೋಗಿದ್ದರು ಎಂದು ಹೇಳುವುದು ಸರಿಯಲ್ಲ. ಈ ಗಣಿಗಾರಿಕೆ ಹೋದಾಗ ನನ್ನ ಪತಿ ಹೃದಯಾಘಾತದಿಂದ ನಿಧನ ಹೊಂದಿರು ಎಂದು ಹೇಳುವುದು ಸರಿಯಲ್ಲ. ಇಟ್ ಈಸ್ ಡಿನೈಡ್.
She denied that it is due to the accident.
But it is clearly mentioned denied for the last three line, it is clearly stated. Due to the heart disease, it is death. The council submit before the trial court suggestion that your husband was died due to the health of the. But the cross examination is denied. For a moment, kindly see,
He is not reading the cross examination. The cross examination, she denies that it is due to the accident. Please read it again.
No. Not that, just give a plain reading. Give a plain reading, then you will understand.
Please, ma'am.
Not to tell the court your case of your client. Just read it. A plain, the meaning of it. Then you will understand.
Please, ma'am.
Because what they are saying is, she said, my husband has not died in a road traffic accident, but he died due to ill health.
My lord, it is not stated. My lord. It is not stated.
This page, file the translated copy. This is smarter.
May suggest, because the other documents are also in Kannada, which I may have to relay.
Why you others are why relevant?
My lord, you will have to
My lord,
kindly see.
It varies, my lord, date of accident, my lord, as on the date, for a moment, my lord, kindly see, I will appreciate, my lord, the matter, fact of this case. My lord, date of accident 7/1/2008, my lord, early morning, my lord, 8 AM. My lord, very same day, my lord, the brother
No,
was.
let it be whatever are the facts. If you agree, if you admit that your
But it-
husband has, that's why I want.
Only one, my lord, in next page, my lord, he has stated, not in his illness. They have suggested, my lord.
Oh, both of you are saying different things. Court has to understand. I need a translation or not for this. I want one document, that's fine. File a translated copy of the
Madam.
deposition in CC number 283 of 2008. This is matter next week.
My lord, one second. My lord, the alleged accident has taken place on 7/1/88. On that day, Panchanama is done and it is in Kannada. My lord, the case is registered in 2005, my lord, 1.5 years later. Probably that document also I may have to bring to.
That is not required because it's only matter of. This is matter next week. Next week, Thursday. No further adjournments will be
2
granted.
weeks, my lord. 2 weeks.
Why 2 weeks,
Allah,
Mr. Counsel?
I'll have to get it given to the company and as far as.
Can't it?
ಅಲ್ಲ ಇನ್ನು ಕೆಲವು ಡಾಕ್ಯುಮೆಂಟ್ ಆದ್ರೆ ಮಾಡಿಸೇ ಬಿಡ್ತೀನಿ ಆಮೇಲೆ ನಾನು try to get the other documents also, some of the other documents which may be relevant.
Why you have not done when the order is passed in the month of February?
No, my lord, it was not, that was not, no, my lord, no translation. I had short time, my lord, because eye operation was conducted. One eye operation was conducted recently, not for translation.
How many times you saw?
I'm sorry, my lord, unfortunately, that is true, my lord. One eye.
Very unfortunate.
One eye operation.
Very unfortunate.
My lord, one eye operation was done. Subsequently, after some time, the other eye operation.
Right from 2024 till
True,
now,
true, my lord.
the matter underwent from the last 1 year.
True, my lord. And I'm not denying that. My lord, 2 eye operations were conducted one after the other. And I was facing some difficulties, and that is true, my lord. I'm not for a moment saying. My lord,
I know, they are also waiting for
I'm
their,
sorry, my lord.
the insurance company has
my lord,
no urgency. Claim still have.
I do accept, my lord. I do accept. Now I'm
Not
sorry.
grant 2 weeks, grant
sorry.
1 week maximum. By the time you should.
My lord, other documents also, it will help me, my lord. One more week.
That is fine.
1 more week should be all right.
1 week is fine. Yes.
Serial number 9.
Melada, by the time I go and
Nine or-
get it given to the company and get it from an official translator, Melada, it would help Melada the court also. I will try to get it from an official translator himself. I'll be obliged if 2 weeks. Some date may kindly be given, Melada, by
You
the.
can get the translation of that?
Hello?
If you can give the translation, I'll hear the matter on Saturday itself.
That one page, my lord.
One page. Get it.
Yes.
Then calls for the respondent, submits that. We'll file the translated copy of the deposition CC. This is matter on Saturday.
22.
Yes.
Serial number 9.
The policy had lapsed.
Where is this council, Kalyan or?
His appeal is for management.
We'll have it on Saturday.
Tomorrow, day after tomorrow.
No representation for the appellant in MFA 411 of 2016. List MFA 411 of 2016 for dismissal. Yes, next.
My appeal also there.
It will come. Dismissal is their appeal. Yes. Both the matters. Done. Any signatures?
ಮಾತಾಡಿದ್ರು ಕೇಳಿದ್ರು ಒಂದ್ಸಲ ಮಧ್ಯಾಹ್ನ ಕರೀತಾರೆ ಅಂತ ಬಂದಿದ್ದಾರೆ ನೋಡಿ ಹೇಳಿ ಕಳಿಸ್ತಾರೆ ಇಬ್ಬರಲ್ಲಿ ಬರಲ್ಲ ಸರಿ ಇದು ಇಷ್ಟು 3 ಇವ್ರಿಗೆ ಮೇಘಂಗೆ 2 ಇವ್ರಿಗೆ
ಡಿವೈಡ್ ಮಾಡಿ 4 ಮಾಡಿ ಡಿವೈಡ್ ಮಾಡಿ
ಕನೆಕ್ಟೆಡ್
ನಾನು ಬರ್ತಾನೆ ಫೋನ್ ಮಾಡಿರುತ್ತೆ ಅಲ್ಲ
ಹಳೆ ಡೇಟ್ ಎಲ್ಲ ಕಳ್ಸಿದ್ದೀರಾ ನಾನು ಬರ್ದ್ಬಿಟ್ಟಿದ್ದೀನಿ ರಿಸೀವ್ ಫ್ರಮ್ ಟೆಂಬರ್ ಟುಡೇ
18/3 ಪೋಸ್ಟ್ ಆಗ್ಬೇಕಾಗಿರೋದೆಲ್ಲ 18 ಎಷ್ಟು ಮೀಟರ್ ಇದೆ ಅದರದ್ದು ಸೈನ್ ಮಾಡಿಸಿಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್ ಇರುತ್ತೆ ಅಂದ್ರೆ ಮೇಡಮ್
ಹೇಳಿ ಮೇಡಮ್ ಇರ್ಲಿಲ್ಲ
ಇರೋ ಏನ್ ಗೊತ್ತಾ ಮೇಡಮ್
ಮೇಡಮ್ಗೆ ಕೊಡ್ತೀನಿ ಕೂಡ ಕಡೆ ಅಂತ ಮೇಡಮ್ ನೀವೇ ಸೈನ್ ಮಾಡಿಲ್ಲ
ಅದೇ ನಾಳೆ ಮಾಡಿ ಅನ್ಬೇಕಷ್ಟೇ ಇನ್ನೇನ್ ಮಾಡೋದು 18 ಯಾವತ್ತಿತ್ತು ಯಾವತ್ತು ಬಿಂದು ಅದು ಯಾವತ್ತಿನ ಆರ್ಡರ್ಪಾ ಯಾವತ್ತಿನ